8, 7, 6, 5, 4, 3, 2, 1. You can begin.
The committee will come back to order. Pursuant to notice, I now call up H.R. 2884, the Affordable Prescriptions for Patients Through Improvements to Patent Litigation Act, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2884 to amend Title 35 United States Code to clarify and improve.
Without objection, the bill is considered as read and open for amendment at any time. I will begin by recognizing myself for an opening statement. H.R. 2884, the Affordable Prescriptions for Patients Through Improvements to Patent Litigation Act, is the final bipartisan measure we are considering today to address ever-increasing medical costs and to help make healthcare more affordable. This legislation concerns some of the most cutting-edge medicines being developed today, called biologics. These are complex, large-molecule drugs made from living organisms. Biologics are expensive to develop and bring to market, and these dynamics are reflected in their high costs and spending totals. The cost of some biologics can reach hundreds of thousands of dollars per patient per year. One way to address the particularly high cost of this class of drugs is to encourage the entry of generics or biosimilars. In 2010, the Biologics Price Competition and Innovation Act established an important mechanism for getting biosimilars to market. However, the process set forth in that legislation for addressing patent disputes between the company that created the biologic drug and the company or companies that want to market biosimilar versions of that drug has so far failed to live up to its promise of streamlining litigation. The streamlining of patent disputes is especially complicated by an emerging practice referred to as patent thicketing. This is when a manufacturer seeks to prolong its exclusive rights to market a drug by seeking a voluminous number of patents with an eye towards fending off biosimilars attempting to enter the market. For example, years after a brand name biologics release, the manufacturer may file claims to the subject biologic that do not incorporate significant changes or claims to a method of manufacturing that the manufacturer does not itself use. These claims tie up biosimilars in litigation and keep them off the market. H.R. 2884 will help to address these tactics and ultimately to lower drug prices. The legislation limits the number of patents that the brand name manufacturer can assert in litigation, which forces the manufacturer to focus on its key patents with the goal of streamlining the resolution of disputes with companies that want to sell biosimilar versions of that biologic. When biosimilars can get to the market quickly, consumers get to see those savings faster. I was pleased to see this legislation advance through the Senate Judiciary Committee earlier this year, and I hope we will see similar action in this committee today. I applaud Mr. Johnson and Mr. Issa, the chairman and ranking members of the Subcommittee on Courts, Intellectual Property, and the Internet, for their bipartisan work to address high drug prices, and I urge my colleagues to support this legislation. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. All around the country, Americans are struggling because of the Biden administration's failed policies. Real wages had been rising under President Trump's leadership before COVID-19, but now they are falling and as inflation rises. The Biden administration now wants to raise taxes and spend trillions of taxpayer dollars for its radical political agenda, while Democrats want to use government power to regulate drug prices. Data shows that by far the most effective way to lower drug prices is through competition from generic drugs. This bill strikes an appropriate balance between maintaining the right of innovative drug companies to enforce their patents while preventing generic drugs from being blocked by heavy-handed litigation tactics. We should work to improve competition and apply market forces to lower drug prices, not to grow government. This is the best approach for American families struggling in the Biden economy and for protecting the innovation that makes our country the leader in biomedical technology. Mr. Chairman, I yield back the balance of our time.
I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 2884, offered by Mr. Nadler. Strike all after the enacting clause.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. The amendment in the nature of a substitute addresses a minor grammatical error in the statement of the effective date of the act. Otherwise, it makes no substantive changes to the bill, and I urge all members to support the amendment. Are there any amendments to the amendment in the nature of a substitute? For what purpose does Mr. Johnson seek recognition? Mr. Johnson, you're muted.
I move to strike the last word, Mr. Chairman.
Gentleman is recognized.
Thank you. I move, the cost of prescription drugs has soared too high for too long in this country. And we spend more on prescription medications than residents of any other developed nation. The fact is that affordable health care is simply out of reach for most Americans. And that's why I introduced H.R. 2884, the Affordable Prescriptions for Patients through Improvements to Patent Litigation Act of 2021, along with my friend from California, Mr. Issa. This bill's name may be long, but its purpose is simple. It seeks to bring down medical costs by streamlining the pathway for alternatives to expensive brand name biological drugs, known as biologics, to get consumers improved access to these alternatives, which are called biosimilars. And it's critical that we do this in order to lower medical costs. In 2010, Congress created a streamlined application process for biosimilars to reach the market through the Biologics Price Competition and Innovation Act, or the BPCIA. The benefit of having more biosimilars available is tangible. For example, one report estimates that over the next 5 years, global pharmaceutical spending will be approximately $160 billion lower than it would have been had biosimilars not reached the market. Although the BPCIA created a robust application process for biosimilars to get to the market quickly, it has not been able to reach its full potential. H.R. 2884 addresses one clog in the current system, which is patent thickening. Brand name biologics have kept their exclusive hold on the market by improperly using the patent system to fend off their biosimilar competition for far longer than contemplated. These efforts include building up a portfolio of late filed patents, which circumstances suggest may be obtained more with a view to block competition than to actually advance medicine. These filings are often timed to keep the brand name drug's exclusivity alive just as the drug's earlier patents begin to expire. The manufacturer of the branded biologic will assert these patents in litigation against the biosimilar applicant, and in the meantime, get to retain their exclusive hold on the market and consequently their hold on Americans' wallets. H.R. 2884 strengthens the BPCIA by encouraging both the brand name manufacturer and the biosimilar applicant to engage more completely in the BPCIA's process, and by addressing manufacturers' patent thickening tactics. To be sure, H.R. 2884 does not intend to discourage brand name manufacturers from identifying new diseases their biologics can treat. That's why patents that claim certain methods of use, such as an indication or method of treatment, are limited. By streamlining and simplifying the patent litigation process, we hope to help make these important and life-saving biologics more affordable for American consumers and more accessible in the marketplace. We should not have to accept high-priced healthcare as an inescapable American burden. This legislation is another bold step in the committee's efforts to lower the cost of staying healthy, And I encourage everyone to support this legislation. And with that, I yield back.
The gentleman yields back. For what purposes does Mr. Issa seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. And I want to thank the entire staff, and particularly Mr. Johnson, for his leadership. This is a modest bill. I'm hoping that today will be a new day, notwithstanding the landslide victory last night in the baseball game. A 13 to
Not
12.
quite a landslide.
13 to 12. This is my time, Chairman. 13 to 12 for Republicans is a landslide. I just want you to know that. We've had some tough years. I'm glad to be back in a winning year, even if that's the win. But moving off that subject and back onto the appropriate subject, I've been both a plaintiff and a defendant in patent litigation. I know how powerful a large portfolio of nondescript or patents can be. I know that if you throw the entire telephone book of patents from a large portfolio at somebody, that it is not only intimidating, but it is incredibly expensive to try to figure out all the places one might infringe and to be sure that you are 100% innocent. And that's why this legislation intends to simply say that if you're going to be the plaintiff, you have to be the plaintiff with reasonable specificity. This committee has worked on legislation in the past that attempts to do it with much greater focus than this. This bill simply limits to 20 patents, and whatever amount of claims are in those, the amount that can be thrown at a defendant for a particular single chemical or biological product. And I think the importance here is this is not like many of the patents that I had or that Mr. Massey might have had or others, where you're talking about patent after patent of a combined product. We are, in this case, very much talking about the examples of a single chemical compound that can only be what it is. It's not a hybrid of thousands of various patents. So unlike perhaps an Intel chip that can be built up over time with many, many, many pieces of technology, the reality is that 20 is a very generous amount of patents to have a defendant have to deal with. If we allow for less, we probably could lower the cost of defense and not in any way limit the plaintiff's ability to make his or her case of patent infringement. And so, again, I make no bones about it. This is modest, but it is intended to at least lower that ever-rising curve of patent litigation cost and, as a result, barriers to entry throughout technology. With that, I again thank the chairman, I thank Mr. Johnson, and I yield back.
The gentleman yields back. For what purpose does Mr. Biggs seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I don't know if this bill's good or bad. I've looked at it. I find it intriguing, and I listened to Mr. Issa, and I think he raises a legitimate concern. I guess my question is, and it's meant to be a question, Mr. Chairman and Mr. Issa, is if you're going to limit the number of patents that a company can defend, why don't you just limit the number of patents a company can get on that? I mean, that's really what you're doing, because a patent is designed to protect that property interest. And what you're effectively saying, and I really truly want to understand this. Why then would you not prevent them from obtaining 130 patents or 120 patents or 50 patents if you're going to say, well, you can really effectively only defend 20? And I'll yield to the gentleman.
Thank you. It's a very valid question. The fact is that limiting the amount of patents somebody could get on a series of products or the number of claims that somebody can get, there are examples where there are thousands of claims for one chemical or biological product or one process for producing it. So the interesting thing is, although we limit the number of patents, we do not limit the number of claims. And so the best way to look at it is if you looked at the contents of this product, and if there were patents on what was inside this product, we're not saying that you couldn't have thousands of different claims. What we're saying is, in order to actually be talking about this product, we want you to limit to 20 patents that you're saying the person producing this product is in fact infringing. Now, there's not a bar from some other additional products. We're simply saying that you can't throw your entire patent portfolio, which is a common practice both in and out of pharmaceutical, a common practice where they'll say, here's my portfolio, you figure out what you infringe. This has been a problem in previous Congresses, though, and I think your point is very good, that this portfolio technique, rather than naming what you infringe and why you infringe it early on, makes it much more expensive for the defendant and, of course, a little laughable by the plaintiff because they're saying you figure it out and you spend the money and you decide if you can beat it. And down the road, we will get around to, in a Markman much later, after millions of dollars, we'll get around to telling you. So this is not the result of an abstract consideration. This is a result of actual experience of how large portfolios are often used and inappropriately used.
Thanks for answering that question. I guess the next question then is, if you're worried about patent thickening and that type of activity, and again, I don't know that I'm convinced that maybe limiting the patents is not more effective, but why 20? Why is 20 the magic number?
Would the gentleman yield?
Mr. Johnson, I'll yield to you.
Thank you, Mr. Biggs. This is a streamlining of the litigation process. It will not affect the number of patents that a biologics maker can obtain, but it will reduce the number of patents that can be asserted in a infringement action that biologics manufacturer institutes against a biosimilar product to 20, but it will also enable the judge to have discretion to consider more than 20 patents if certain conditions occur.
So I don't want to cut you off because I just want to reclaim my time because it's fading quickly, and I understand what you're saying. I think you're saying similar what Mr. Issa said, just in
Exactly.
Different vernacular. I guess my question ultimately will be that, so what you're telling me is that 20 is a random, arbitrary number.
20, I appreciate
yield
that.
to you.
20 is arbitrary, but it is generous. It is probably 10 times greater than that which realistically should be used in most cases. But it does attempt to stem somebody's ability to say, here's my entire portfolio of hundreds of patents or thousands in some cases.
Mr. Chairman,
My time's expired.
Gentleman's time has expired. For what purpose? Does Ms. Jackson Lee seek recognition? Gentlelady is recognized.
let me try to put this in the terms that whenever we do things in this room of justice, I try to reflect when we leave these hollowed walls, how it will impact the constituents that we represent, Mr. Chairman. And the question that we've been debating for so many years deals with issues of prescription drugs and the cost of them, particularly if we've interacted with our constituents, those who have very unique or diseases that are rare. The cost of treatment is unbelievable, and it is driven a lot by the necessary prescription drugs that they must have. So when I think of thickening and lawsuits, And the reason why I'm supporting this legislation is because of the way it amends the process for resolving patent infringement claims for biological products by limiting the number of certain patents that a biological product manufacturer can assert in an infringement case. It's all about lowering the cost of prescription drugs or those that generate the relief to sick people. Because patent thickening occurs when a brand name drug manufacturer prolongs its exclusive rights to market a drug by filing numerous patent claims to extend the exclusivity of the underlying drug. And that is where the cost comes. When you have an equally good product, or when this exclusivity continues by way of extending it with patent lawsuits, and the defender is usually lopsided in terms of defending the litigation, cost, ability, and how many lawsuits can they succumb to. So the process through which patent thickening occurs has been described even by one of our financial periodicals, Forbes, as the biggest driver of raising drug costs. In the backdrop of COVID-19, but more importantly, infectious diseases, I know that researchers are going to be working more extensively on fighting off infectious diseases with, in addition to vaccines, you have to have the drugs that will treat those who are infected or who have COVID-19 or the Delta or another variant. So in response to companies engaging in patent litigation that must address dozens of patents, 2884 amends our antitrust laws to limit parties to the number of patents. I'm glad Mr. Johnson has indicated that this 20 number is not a finality, but there are exceptions that can be utilized. So I just think if we look at what we're doing as it impacts people outside of this room, anything I can do to help contribute legally and give a process so that there is due process and justice to bring down the cost of prescription drugs and not brandish, ban, eliminate prosperity of the large brand name companies, which argue that they can't do their research if they don't have the ability to litigate and the ability to hold on to exclusivity forever and ever. I think this is a fair response. I thank the sponsors of this legislation, and I would ask my colleagues to support it on the basis of its ultimate results, bringing down the cost of prescription drugs. I yield back, Mr. Chairman.
Gentlelady yields back. For what purpose does Mr. Cicilline seek recognition?
I move to strike the last word, Mr. Chairman.
Gentleman is recognized.
H.R. 2884, the Affordable Prescriptions for Patients Through Improvements to Patent Litigation Act, is a vital companion to my bill, the Affordable Prescription for Patients Through Promoting Competition Act of 2021, in addressing drug manufacturers' abuse of our patent system. This bill tackles abuse of our patent system by reforming patent litigation practices so that delayed and excessive patent filings are not used surreptitiously to keep drug prices high. It is perfectly legal for a drug manufacturer to bring forth patent claims for its manufactured drugs, as well as challenges to biosimilars that may infringe on those patents. However, the patent process often is abused by a process known as patent thickening, in which drug companies strategically file excessive patent claims with the sole objective of keeping the exclusive right to the underlying drug for as long as possible. This process delays the introduction of biosimilars and generic drugs into the market by keeping generic manufacturers caught up in litigation with the patent holders, which keeps important drugs at higher costs. This bill addresses this problem by amending the process for resolving patent infringement claims for certain drugs, known as the patent dance, by limiting the number of certain patents that a drug manufacturer can assert in a patent infringement action. This would encourage drug manufacturers to examine and bring forth their strongest patent claims, which would streamline litigation and reduce the artificial barriers that generic drug manufacturers face when trying to enter the market and produce lower-cost drugs for our constituents. I want to thank Congressman Johnson and Congressman Issa for coming together to work on this important legislation, as well as Senators Blumenthal and Cornyn for their work on this important issue on the Senate side. And I applaud Chairman Nadler for bringing this important bill to a markup today and urge my colleagues to support it. And with that, Mr. Chairman, I yield back.
Gentleman yields back. Does anyone else seek recognition? If not, the question occurs on the amendment in nature of a substitute. This will be followed immediately by a vote on final passage of the bill. All those in favor respond by saying aye. Aye.
Aye.
Opposed, no. In the opinion of the chair, the ayes have it, and the amendment in nature of a substitute is agreed to. A reporting quorum being present, the question is on the motion to report the bill H.R. 2884 as amended favorably to the House. Those in favor respond by saying aye. Aye.
Aye.
Opposed, no.
No.
The ayes have it, and the bill is ordered reported favorably. The ayes have it, and the bill as amended is ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 3617, the Marijuana Opportunity Reinvestment and Expungement Act of 2021, or the MORE Act of 2021, for purposes of markup, and move the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 3617, to decriminalize and deschedule cannabis to provide for reinvestment and
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. I am proud to have introduced H.R. 3617, the Marijuana Opportunity Reinvestment and Expungement Act, or the MORE Act, joined by my colleagues Representatives Barbara Lee, Earl Blumenauer, Nydia Velasquez, Sheila Jackson-Lee, and Hakeem Jeffries, as well as many colleagues on this committee who have signed on as co-sponsors. This long overdue and historic legislation would reverse failed federal policies criminalizing marijuana. It would also take steps to address the heavy toll this policy has taken across the country, particularly among communities of color. I have long believed that the criminalization of marijuana has been a mistake. The racially disparate enforcement of marijuana laws has only made it worse, with serious consequences, particularly for communities of color. This issue is not new to Congress. There have been many members who have introduced bills upon which provisions in this bill are based. For instance, Representative Barbara Lee has championed many measures reflecting policies in the MORE Act, and I applaud her longstanding leadership on this issue. Representative Earl Blumenauer has also been an indefatigable advocate and has supported everything we have done to get to where we are today. I thank him as well. Last Congress, the House voted in an overwhelmingly bipartisan manner to address this issue. Unfortunately, the Senate failed to act. So today we are moving forward again. Without any further delay, we need to reform these unjust laws. The MORE Act would make 3 important changes to federal law. It would, 1, remove marijuana or cannabis from the list of federally controlled substances. 2, authorize the provision of resources funded by a federal tax on marijuana sales to address the needs of communities that have been seriously impacted by the war on drugs, including increasing the participation of communities of color in the burgeoning cannabis market. And 3, provide for the expungement of federal marijuana convictions and arrests. Whatever one's views are on the use of marijuana for recreational and medicinal use, the policy of arrests, prosecution, and incarceration at the federal level has proven unwise and unjust. The MORE Act would address some of these negative impacts. For example, it would establish an opportunity trust fund within the Treasury Department to fund federal programs to support communities adversely impacted by the war on drugs. These programs would provide services to individuals, including job training, reentry services, and substance use disorder services, and would provide funds for loans to assist small businesses that are owned or controlled by socially and economically disadvantaged individuals. Our bill would also provide resources for programs that minimize barriers to marijuana licensing and employment for individuals adversely impacted by the war on drugs. The collateral consequences of a conviction for marijuana possession, or even just for an arrest, can be devastating. For individuals with a criminal record, it can be difficult or impossible to vote, to obtain educational loans, to get a job, to maintain a professional license, to secure housing, to receive government assistance, or even to adopt a child. These exclusions create an often permanent second-class status for millions of Americans. Another important provision of the MORE Act recognizes this injustice and addresses these harmful effects by expunging and sealing federal convictions and arrests for marijuana offenses. In my view, criminal penalties for marijuana offenses and the resulting collateral consequences are unjust and harmful to our society. The MORE Act comprehensively addresses this injustice, and I urge all my colleagues to support this bill today. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. This bill not only decriminalizes and legalizes marijuana, but it creates a stimulus program for the marijuana industry. Our constituents are worried about their families, their jobs, their small businesses, and their communities. One thing I can tell you they're not worried about is creating a new program to help provide stimulus to the cannabis industry. We have a security and humanitarian crisis on our southern border that is only exacerbated by Biden administration's incompetence and indifference. We all saw a botched withdrawal from Afghanistan that has brought over 60,000 Afghan evacuees to the United States, some of whom allegedly assaulted their spouse, children, and even a female U.S. service member. As Democrats have embraced the mantra of defund the police, violent crime is on the rise in major urban centers. On Monday, this past Monday, the FBI released its Uniform Crime Report for 2020. It revealed that homicides in 2020 increased nearly 30% from last year. From the year before. The 2020 jump in homicides marked the largest single increase that the FBI has seen since it began collecting data in the 60s. But are we here today to discuss solutions to these pressing issues? The fact that crime is up, that inflation's at record levels, that the border's in a crisis? No. Are we meeting to fix the border crisis or to turn around the Biden economy or stop the far-left assault on law enforcement? No, we're here today to discuss a bill to subsidize pot. We should be working on important issues to help our constituents. Instead, we see our colleagues bring back up a radical proposal to decriminalize, legalize, and use the federal government to promote the use and commercialization of marijuana. Americans don't need this radical, out-of-touch Democrat priority. In addition to this bill's many problematic provisions, it fails to provide even the most safeguards, basic safeguards against marijuana abuse. The bill provides no limits on or requirements to clearly identify the potency of the marijuana or its extracts or concentrates. Marijuana is far more potent today than it was decades ago. In addition, this bill fails to impose a minimum age limit, a restriction recommended by the Surgeon General due to the unique harm that marijuana poses to developing brains. According to the Surgeon General, the human brain continues to develop from before birth into the mid-20s and is vulnerable to the effects of addictive substances. Frequent marijuana use during adolescence is associated with changes in the areas of the brain involved in attention, memory, decision-making, and motivation. Marijuana is also known to cause impaired learning in adolescence, such as declines in IQ, school performance, and life satisfaction. THC, the chemical primarily responsible for marijuana's psychological effects, poses significant risk, particularly in higher concentrations. The Surgeon General has concluded that, quote, the risk of physical dependence, addiction, and other negative consequences increase with exposure to high concentrations of THC and the younger the age of initiation. He went on to say higher doses of THC are more likely to produce anxiety, agitation, paranoia, and psychosis. But rather than implement these common sense provisions to protect American children, Democrats want to punt these decisions to unelected bureaucrats. Even for those who think that this is a good idea to legalize marijuana, the approach reflected in this bill is short-sighted. We need to spend more time considering the effect of marijuana legalization on the American public, and especially the effect this bill will have on younger Americans. I strongly urge my colleagues to vote no on the marijuana stimulus bill. The American people expect, and frankly deserve better from all of us. I yield back.
Gentleman yields back. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 3617, offered by Mr. Nadler. Strike all that follows after the
Without
enactment.
objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I recognize myself to explain the amendment. The amendment in the nature of a substitute simply removes, quote, of 2021 unquote, from the title and references to the title within the bill. Otherwise, it makes no substantive changes to the bill, and I urge all members to support the amendment. Are there any amendments to the amendment nature of a substitute?
Mr. Chairman.
For what purposes, Ms. Jackson Lee seek recognition?
Strike the last word.
Gentlelady is recognized.
Mr. Chairman, thank you so very much, your leadership, and of course, the co-sponsors of whom you have named. I'm very pleased to have been an original co-sponsor, and I would like to thank the members of the Subcommittee on Crime, Terrorism, and Homeland Security for their initial and strong support, and of course, all of the members of the House Judiciary Committee. I'm an original co-sponsor of H.R. 3617, the Marijuana Opportunity Reinvestment and Expungement Act of 2021, or the MORE Act of 2021. I'm proud to support this long overdue measure and to encourage the rest of my colleagues to do so as well. For those of us who've had the privilege of being on the House Judiciary Committee, Mr. Chairman, I know you include yourself among many others, we know that we have been working on this issue as well as other members for such a long time. We've been to the floor of the House, we've been discussing it in our committees, and we have worked. And so this is an important criminal justice reform bill, and I commend the chairman for once again introducing this bill and bringing it before the committee. In fact, it consolidates the discussions that we've had about the over-incarceration of individuals who were addicted or caught up in the cycle of drugs, many of them people of color in inner-city neighborhoods. To summarize, the provisions of the MORE Act fall into three main categories. And let me say that one of the things that is so important is it puts the government, the federal government, as the head of real policy as opposed to the tail. As I will indicate in my statement, so many other states have already moved on this. First, it would remove marijuana or cannabis from the list or the schedule of federally controlled substances. This means that going forward, individuals could no longer be prosecuted federally for marijuana offenses, and that is what has been the upset, if you will, of really, truly dealing with criminal justice reform, because they're not prosecuted in the state, but we can prosecute them federally with time. This does not mean that marijuana would now be legal in the entire United States. It would simply remove the federal government from the business of prosecuting marijuana cases and should leave the question of legality to the individual states who have already moved forward. Those states choosing to decriminalize can do so without ongoing interference from the federal government, and those states that choose to continue to make marijuana illegal can continue to do so as well. Second, the bill would establish a taxation structure to collect a sales tax on marijuana, which over the course of 5 years would increase from 5 to 8%. The funds collected through this tax will be used to establish a trust fund to reinvest communities ravaged by the war on drugs, and particularly communities of color. I am made aware of an issue of my dear friend and colleague who supports this bill, of our friends on the other side, and I want to say that this should be looked at by Ways and Means and Energy and Commerce and Food and Drug Administration. Look forward to working on the issue dealing with medicinal marijuana. The trust fund will be used for rehabilitation and reentry programs in the Department of Justice and for programs in the Small Business Administration to ensure that the burgeoning marijuana market is diverse and opens up opportunities for entrepreneurship in communities that have been adversely impacted by the war on drugs. Let us not singularly suggest that this is only people of color. This is rural and urban. These are small businesses wherever they are that can finally have an opportunity. We want an economic engine to be in urban areas, but we want it to be in rural areas. And there is growth of marijuana farms and activities in rural America. Let's move off of addiction and opioids and get treatment and have people to function in a legal system. Finally, the bill would expunge and seal federal marijuana arrests and convictions and resentence offenders as appropriate, a much-needed part of this bill to try to undo the damage that has been done to our communities by decades of unjust enforcement. Thousands of men and women have suffered needlessly from the federal criminalization of marijuana, particularly in communities of color, and have borne the burden of the collateral consequences for those ensnared in the criminal legal system that have damaged our society across generations. You don't know what it's like to have 10 years thrown at you, 25 years use of marijuana and or standing on the corner with marijuana more than the amount that would keep you out of the system. The laws enacted for the purpose of the war on drugs have led America to imprison more people than any other country. Mr. Chairman, I know that you are well aware of the legislation that we passed when the former chairman was there about opioids. and we didn't get any relief with this bill. But expunging and sealing the arrest and conviction records of people affected by the cannabis laws would remove barriers that help create a permanent second-class status for millions of justice-involved Americans. Our outdated federal laws and policies unwisely require scarce law enforcement resources to be expended on cannabis. Cannabis does not fit the definition of a Schedule I drug, and federal law must be updated to reflect this reality, just as the majority of the states have already done. 37 states, the District of Columbia, Puerto Rico, Guam, have adopted laws. 18 states, the District of Columbia and the Northern Mariana Islands, have adopted laws for legalizing cannabis for adult recreational. Total of 47 states have reformed their laws in one form or another. The state legal cannabis industry already employs almost 250,000 people, and the federal government needs to get out of the way of state-level decision-making for their citizens. Remember, this is an economic engine as well. We need to open the door to research, better banking and tax laws, and medicinal use of it, and we need to help fuel an economic growth in this country. Finally, we need to do this without continuing to spend federal resources on criminalization and unjust incarceration for marijuana offenses. We need to pass the MORE Act, and that is why I support it today. Thank you very much, and I yield back my time.
The gentlelady yields back. I will now recognize myself. For a brief statement. I am not going to repeat the rationale for the bill, the reasons for it outlined by myself earlier and by Ms. Jackson Lee, but I do want to answer a question or a point raised by the ranking member, Mr. Jordan, in which he talked about the effect that marijuana and THC have on developing brains of young people. This is true. It is also true, obviously, of nicotine in a much worse way. But we don't put nicotine users in jail. We discourage their use. And that's essentially the same approach we'll take here. Nicotine is a far more is a far more harmful drug than marijuana. But we don't put people in jail. We simply discourage its use. And what we're doing here is to discourage the use of marijuana, but to take it off the controlled substances list where it never belonged, and to offer to reduce the collateral consequences of the former placement on Schedule I. And with that, I yield back.
Mr. Chairman, would you yield? Mr. Chairman, would you yield for one moment?
Certainly.
I just had a question. I understand that we don't put nicotine users in jail, but underage nicotine users, but we certainly put people who sell nicotine to underage users in jail. And I'm wondering whether, and we give them criminal penalties, I'm wondering whether you would amend the MORE Act to include that.
Well, the federal government doesn't do that, and under this bill, federal government won't do it, but the states can do it if they want to. For what purpose does Mr. Roy seek recognition?
Move to strike the last word.
Gentleman is recognized.
Well, I guess this week, as we're considering $3.5 trillion bills, we now know the economic recovery plan of our Democrat colleagues, which is to build the job creation effort on the back of pot legalization. Look, I think there is some bipartisan consensus here about wanting to give latitude to our states. I'm a big advocate of federalism, as my colleagues on this committee knows. I supported last year a bill to give prosecutorial discretion and to encourage prosecutorial discretion among federal law enforcement officers. And I used to be in the U.S. Attorney's office, as many of my colleagues on this committee did as well. And certainly support giving that kind of discretion to ensure that we're not overstepping our bounds, particularly in states that have made a choice about simple possession. But this bill is absurd. I mean, it's just completely absurd. And the American people, we're creating a cannabis justice office within DOJ that requires the Assistant Attorney General to appoint a director to award grants, enter into contracts on behalf of the Cannabis Justice Office, and hire as many employees as needed for the Cannabis Justice Office to create community reinvestment grant programs, to spend all sorts of money to create a cottage industry to the federal government for pot. I mean, this is just nonsense, right? I mean, this isn't, again, if this is the economic recovery program for my Democratic colleagues, I mean, I guess that might make sense, and maybe we all need to go smoke
Would
pot.
the
because
gentleman
this is
yield?
absurd. I'll yield briefly because I have a couple other points to make.
Yes, I simply want to say that, again, the states under this bill will continue to have complete discretion to do what they want, to keep pot illegal, et cetera, and that will have effect within those states. And secondly, the pot industry that we're setting up, as you characterize it, it will cost nothing because it will be financed entirely by a tax on marijuana growers.
Okay, reclaiming my time, the chairman, it makes my case for me, right? In the minds of my Democratic colleagues, right, we create industry by taxing and then having programs in the Department of Justice, like the Cannabis Justice Office, to create a economic industry. Look, here's the deal. When I was in the U.S. Attorney's Office, not once, and in all the people that I worked with who prosecuted drug crimes their whole careers, because I was there briefly, not once were they ever going around and trying to find the individual who was smoking a joint behind the bleachers at a football game or was caught with a small bag. It was almost entirely, and I'm sure, and I know that there are exceptions, and I know the terrible history with respect to abuse of power by authorities with respect to race, and these are all things that we should tamp out, and we all agree on that. But the idea that the federal government typically, that U.S. attorneys' offices typically are going around and putting people in jail because of simple possession is just not true, right? When you have a prosecution for someone for simple possession, it's because you've cut a deal and you've worked out an arrangement because the dude was doing bad stuff and you know it and he knows it and he can give up sources, and then you cut a deal for possession or something else, and then you're able to go after the real bad guys. And almost all of these people moving mountains of pot are moving mountains of other stuff, including, by the way, human beings right now in concert with cartels and moving human trafficking because there are wide open borders. The fact that this bill goes well beyond just simply descheduling, which I would probably oppose, but if we were having a simple debate on descheduling, I would at least entertain some notions of maybe we could change the scheduling or otherwise. But I think it is problematic. And I think this bill is flawed on its face by virtue of the fact that it's creating mountains of additional federal programs and offices under the auspices of supposedly legalizing pot. One final point is just this. I, for one, have not bought into this narrative that, the fact that we had a significant number of people incarcerated was inherently in and of itself a bad thing. The fact is we want to have our streets be safe. And frankly, right now, we are allowing too many people to get away with crimes because, frankly, we're defunding cops. We're going after all the people that are engaging in law enforcement. And now we're trying to take away another tool for going after bad actors, when, in fact, we have rampant crime increasing across the country, murder rates skyrocketing, and we're basically reverting back to the failed policies of the 70s and the 80s that gave us the movement to try to clamp down in both the war on drugs and to clamp down on gangs and to clamp down on illegal activity. And so I, for one, have continued to be a pro-justice member of Congress, and I will oppose it.
Gentlemen,
Mr. Chairman.
the gentleman yields back.
Chairman.
For what purpose does Mr. Cohen seek recognition?
To strike the last word and many of the words over the last
Gentleman is
3 or 4
recognized.
decades. Thank you, Mr. Chairman. It's good to have this bill before us, and its time has come and time came a long time ago. I want to recognize Mr. Blumenauer, who with me has been a sponsor of these type of bills for at least 15 years. Really, Mr. Blumenauer preceded me in Congress, although my work was even in the state Senate in Tennessee and before that. I'd like to remember Maurice Henchy, who was a leader in trying to get marijuana descheduled and change that. Dana Rohrabacher, a Republican, was a leader, and he saw the need to reschedule marijuana, and he was an advocate. I know Mr. Massey was big on hemp, and it's a cousin. But the bottom line is the war on drugs was a failure, and marijuana is less harmful to our society than alcohol by far and nicotine. And it should not be a Schedule I drug, never should have been a Schedule I drug. It was only put there years ago because of antiquated thinking, if you call it thinking, to try to get people angered and direct their anger at Latinos, and African Americans, and later at white hippies. That's what Nixon did. That's what Harry Anslinger did in the 30s. That's what Nixon did in the 70s, was to get people to get upset with his enemies who opposed the war in Vietnam, and Anslinger needed a job. And they found a way to criminalize marijuana in such a way that people looked at it as just something that musicians did, African-American musicians, jazz musicians, Hispanics did, and then later white hippies did. They tried to disenfranchise them, take away their rights by convicting them, putting them in jail, and they were fodder for a criminal justice system gone astray. The fact that this bill gives money to African Americans to get into the business of marijuana is right, because otherwise it's going to be simply Caucasian business, and that's what it is. African Americans are disproportionately affected by the arrests, as were white, quote-unquote hippies, and they were bludgeoned. Schedule 1 is heroin, ecstasy, methamphetamines. Marijuana is not in that class. I was shocked to hear Mr. Jordan's comments. This is someplace we should have bipartisanship, and we had it with Dana Rohrabacher, and we had it with some Republicans. We had it with Matt Gaetz. Matt's been a leader on this. There have been a lot of Republicans who over the years have joined with us to make this more of a bipartisan approach. I remember a time I was on an airplane flying back from Nashville, and I was a state senator, and a guy said to me, he said, "You know, Senator Cohen, I don't support a lot of what you do, but I like your positions on marijuana and pets." Of course, I had a bubble go over in my head of him getting high and playing with his kitten or his dog. But that's something we could be bipartisan on. Pets and pot. And we should be. Because it's just, Americans have a right to life, liberty, and the pursuit of happiness. And people who are smoking marijuana, part of what they're doing is the pursuit of happiness. And for the government to put them in jail and take away their rights, and as we know, they can't get food stamps, can't get college scholarships because of marijuana convictions, that's absurd. Just totally absurd. So this bill is an effort in the right direction. It's a justice bill. And just about every time people have voted on this, they voted for it, to decriminalize marijuana, to legalize marijuana, to make it used for medical marijuana. You got states like Louisiana that hadn't let the people vote, but if they would let the people vote, it would be 2/3 for it. It's 2/3 to 3/4 everywhere. So to my Republican colleagues, come into the 21st century on something. And this is a place where citizens, I think Colorado has shown it, they voted for marijuana. It's legal there, it's a business. And it really hadn't affected the Denver Broncos' performance. It hadn't affected the crowd's performance. Mr. Buck, would you like me to yield?
I appreciate that.
And it'll help our grocery stores.
I appreciate the work we're doing together, and I was just looking for some more. I love pets, and I'm wondering what you're doing on pets that I could join you on.
We've got a whole bunch of bills, and I'll send them over to you. We're good on pets, and we're good on pot.
I appreciate it. Thank you.
Thank you, and I yield back the balance of my time.
Mr. Chairman,
The gentleman yields back. For what purpose does Mr. Shabbat seek recognition?
move to strike class forward.
Gentleman is recognized.
Thank you, Mr. Chairman. This discussion is becoming more and more interesting on both sides, I think. And, I think one thing Mr. talked about this, but basically we're seeing more and more of what my colleagues on the other side of the aisle, the Democrats, what their agenda really is. I mean, it's legalizing drugs, it's defunding the police, it's open borders, it's raising your taxes. And we could go on and on from there.
Would the gentleman yield for a second for helpful?
I will after a while if I have some time left.
You forgot communism and socialism.
Excuse me?
Not to add in communism and socialism.
Oh, you can add that if you'd like to, as I'm sure you would. I've heard a number of my Democratic colleagues talk about this being an economic engine. you know what would be an economic engine is not raising our taxes. But the Democrats are trying very hard to do that right now to pay for this $3.5 trillion boondoggle that they haven't been able to get the votes yet. They may do it, they may not. We really don't know. It's interesting to watch, but it's incredible some of the stuff that's in there. And the president the other day, it doesn't matter how much it is, it could be 10 trillion or 20 trillion, because he says it doesn't cost anything. I mean, it's pretty incredible. That's right up there with Nancy Pelosi, our speaker, having said that we got to pass the bill to find out what's in it. This thing is just incredible. We don't know how large it is, but it doesn't matter because it won't cost anything. Nobody's going to have to pay for it, according to the president, President Biden. But this particular legislation that we have before us today, I mean, use your common sense. The chairman mentioned before nicotine, and you know, one of the big differences is obviously nicotine doesn't impair one's driving as marijuana does, and alcohol. And like lots of my colleagues would say, well, we allow alcohol, why not marijuana? They both impair driving, no question about that. And we've already got enough impaired drivers out there who are intoxicated with alcohol, and now we want to have people smoking pot as well, more and more, because if we legalize it, there will be more. There's no question about that. You know, the bottom line is we ought to be doing what's in the best interest of the American people, what's going to keep them safe. Yes, we have freedoms, we have rights, but we know that young people will end up smoking more marijuana if you legalize it. That's also going to make education in this country. I'm a former school teacher. It's already a challenge right now, and we're competing with the Japanese and the South Koreans and you name it. But this is just going to infringe even more on that effort that we're trying to get our kids up to the standards so we can compete with those countries that I just mentioned. So this is just, you know, wrong-headed legislation in my view. And if you're looking at, again, about the Democrats' agenda and just what they've been bringing up in this Congress and other things on the law enforcement front, you know, defunding the police, taking away qualified immunity from police officers, which basically means that police officers can be sued personally. Who's going to want to be a police officer in this country if you can sue them personally and go after their kids' college funds, their pensions, and that sort of thing? And we've seen crime rates going up in cities all across the country because the police officers are afraid to be aggressive at all or proactive at all, because in some places they would be able to be sued personally. So this is consistent with that whole line of being soft on crime. You know, there's a number of communities across the country where we've had prosecutors, for example, who are extremely weak on crime. They don't want to prosecute anybody anymore. We've seen crime going up in those communities. They're doing away with cash bail so that you want to get the police officers arrest somebody. They're out on the street before the police officer has time to even do the paperwork on that. And that's making our communities less safe. So this is right in with those other things, legalizing marijuana. What's next? Is it going to be cocaine, crack, LSD, you name it? That's why I'm going to vote no, and I would urge my colleagues to do the same. Yield back.
The gentleman yields back. For what purpose does Ms. Dean seek recognition?
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. I rise in support of the MORE Act, and I'm a little baffled and puzzled by the previous speaker. I'm not sure what any of that had to do with the MORE Act. When we know better, we do better. Last year, I lent my voice to the historical vote that passed the MORE Act through the House, and I proudly do so again. I have discussed the importance of treating addiction on in this chamber time and time again. Criminalization does not work and is not the answer. In 2021, we know that it is ludicrous that marijuana be on Schedule I, drugs which include bath salts, heroin, meth. More importantly, the MORE Act heavily emphasizes reparative justice through social equity programs that acknowledge those who have been most impacted under criminalization, Black and brown communities. As we know, individuals with a marijuana conviction are riddled with punishments that go beyond the risk of jail time to include a prohibition from obtaining federal benefits, from accessing student loans, or even a pathway to nationality due to marijuana's criminalized status. To correct these historical injustices relating to prohibition, the MORE Act expunges and resentences marijuana convictions at the federal level to support the development of expungement programs at the state and local level. It also prohibits immigration penalties based on marijuana. These are only some of the highlights of the impact of this important piece of legislation. The MORE Act will join a bipartisan effort to right our historic wrongs. I was happy to join my colleagues on both sides of the aisle to pass Representative Jeffries' Equal Act. I hope for a similar wave of support when I join Representative Trone as the co-lead for the Fresh Start Act next month. Our bill will establish a grant program for states to facilitate automated record sealing and expungement. This will allow for Americans to not be burdened for the rest of their lives by one incident. When we know better, we do better. And today we have the opportunity to begin to address some of the historical injustices of our past. With that, I lend my support to the MORE bill, and I thank all of the prime sponsors of this bill. I encourage all of you to do the same. Mr. Chairman, I yield back.
Mr. Chairman?
The gentlelady yields back. Does Mr. Jordan seek recognition?
Well, unless there's someone in front of me?
For what purpose does Mr. Gates seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I am a proud co-sponsor of the MORE Act because the federal government has screwed up marijuana policy in this country for a generation. We lied to people about the effects of marijuana, and then we used marijuana as a cudgel to incarcerate just wide swaths of communities, and particularly in African-American communities. And so I am not offended by the concept of restorative justice in marijuana policy, because we cannot honestly say that the war on drugs impacted suburban white communities the same way it affected urban Black communities. We can't say that marijuana enforcement was happening the same way on the corner than it was happening in the fraternity house. And we have an opportunity to fix that problem. You know, the war on drugs, much like many of our forever wars, has been a failure. If there's been a war on drugs, drugs have won that war. And so rather than continuing to make a small group of people continue to pay the price for those bad decisions, we ought to democratize access to a federalist system that allows states to make these decisions. And I respect the concerns of my Republican colleagues, but it seems to be a little inconsistent with our perspective on federalism to say that we don't want states to innovate and develop their own programs and to test and to fail and to succeed and then to copy each other's best practices in a way that improves quality of life for people. I heard the ranking member make comments on the developing brain, and I pay close attention to that because I do believe the ranking member of the Judiciary Committee likely has the best developed brain in my conference. But there is specific science that we've had access to that informs on brain development. And it all has to do with when brain cells stop dividing. So up until the age of 24, for most people, your brain cells are still dividing. And so things like football or wrestling or soccer or a number of things can be harmful during that process. And that's why we take such care for the brain. That's why we encourage the innovation around protective equipment. After 24, those cells stop dividing. And there is very compelling research that suggests that the utilization of cannabis can actually protect the brain after that division from some degenerative brain diseases. I mean, I think in the country right now, we are all seeing the impact at a very high level of when someone starts to have mental acuity that declines. And if we are able to have access for people to a medicine that would help, I would think we would want that for everyone, from the least powerful to the most powerful. Taxes are an issue raised in the bill, and I want to thank Chairman Nadler and Congresswoman Jackson Lee for hearing me out on this point. In my state, in Florida, there is not permissive adult use. It is a medical program. So the people who use marijuana in my state use it for medicine. Nowhere in America today do we tax medicine. And I do have some concerns about the provisions of the bill that, for the first time, would impose a tax on people who are trying to get well or get better. And so I hope as we work on the legislation going forward that we think about people exercising adult use rights versus people participating in a medical program, both from the consumer and from the grower standpoint. I really like giving this speech every year, but it does sort of feel like deja vu, Mr. Chairman. And I regret that deeply because we ought to pass bills into law. This bill is not going to become law. The Senate won't take it up and pass it. I wish they would, but they won't. There is legislation they would take up and pass, the States Act, which I think might underdo it a little on some of the needed restorative justice, but that would at least build some momentum. I think about the years Mr. Blumenauer's been working on this, and frankly, how little progress we've made on something that is so overwhelmingly popular in the country, and we are paralyzed. And the result of that paralysis is that patients have higher costs, that businesses have a problem meeting the needs of their patients, and we have a very disjointed system. So when I asked the chairman in the last Congress whether following the passage of the MORE Act we might consider taking up the States Act, the chairman's response to me was, no, we want to negotiate off the MORE Act with the Senate, which as a legislative strategy made some sense to me at the time, but it didn't work. And here we are, and we don't have a bill. So it's just my sincere hope that we take a strong stand, pass the MORE Act, make the right, just, proper arguments regarding federalism and restorative justice, but then we not merely surrender the debate to those who want to see us divided and paralyzed, but we advance that debate with legislation that could actually pass the Senate. I thank the committee's indulgence, and I yield back.
The gentleman yields back. For what purpose does Ms. Scanlon seek recognition?
I move to strike the last word.
Gentlelady is recognized.
You know, in recent years, we've seen states lead the way and demonstrate how to responsibly regulate cannabis. But our federal policy has lagged behind. We've seen in Pennsylvania this disconnect between federal and state policy can have harmful and sometimes tragic consequences. Pennsylvania is a state that allows medical cannabis as a treatment for opioid addiction. And many Pennsylvanians have safely used medicinal cannabis to treat their addiction symptoms. But across Pennsylvania, confusion about the legal status of cannabis and the mismatch between federal and state laws has caused healthcare providers to avoid federal grant funds or to turn away people who can legally use cannabis. Recently, we've heard about a Pennsylvania man who'd been using medicinal cannabis to treat his addiction symptoms, but he was denied access to a federally funded state program for addiction treatment because he had a medicinal marijuana card. He died of an overdose just a couple weeks later. So this tragic incident is one of many examples of how our federal drug policy is failing Americans. We shouldn't continue to criminalize safe cannabis use, and we absolutely cannot continue to keep people in prison for low-level cannabis-related offenses. I strongly support the MORE Act and look forward to passing it out of committee today. Thank you. I yield back.
For what, the gentlelady yields back. For what purposes does Mr. Jordan seek recognition?
To strike the last word and talk on the bill.
The gentleman is recognized.
Thank you, Mr. Chairman. I actually agree with a number of things my good friend and colleague, Mr. Gates, from Florida said. Maybe we can work on an amendment to say that, put an age in here of 25. It's why I referenced that in my opening statement, because we know it impacts younger people differently. But this is not just a bill. I mean, this is important. Not just a bill to legalize marijuana for medical use, which I know the gentleman from Florida supports. This is not just a bill to legalize marijuana for recreational use. This is a bill that subsidizes the marijuana industry. Page 65 of the bill. The administrator of the Small Business Administration shall establish and carry out a program to be known as the Cannabis Opportunity Program to provide loans. Wow. Page 76, the administrator may not decline to make a loan or a grant under this subsection, and eligible if they're in the cannabis-related legitimate business. So here's the deal. This is not about legalizing marijuana, not just about legalizing it for medical use, which the gentleman from Florida pointed out, veterans and others are using it for that. I understand, not just for recreational use. This is a subsidy program. Think about it. Typical family out there. All kinds of crazy policies they've seen from our Democrat friends: defund the police, pay people not to work, open up the border, don't even have a border. And now, oh, by the way, your tax dollars are going to be used to grow the cannabis, the marijuana industry. Such a deal for the taxpayers. Just what the folks in the 4th District of Ohio, I get the privilege to represent, just what they want. I'm sure of that. In fact, I've not had one single person come up to me and say, do this. But I get comments every day about their concern about rising crime. They're concerned about what's happening on the border. They're concerned that they can't find enough people to work. Every single employer I talk to tells me that. Not just in Ohio, but all over the country. But no, we're going to have a bill that actually is going to use their tax dollars, American tax dollars, to grow the cannabis industry at a time when we got all these other major problems. That was the focus of so I hope we have some amendments. And I know that the gentleman from Florida supports the amendments. I think Mr. Massey's going to have an amendment to get rid of this subsidy stimulus program for the cannabis industry. I hope someone will have an amendment, probably will from our side, to limit the age where this all applies to protect those younger developing minds that we all want to protect. That's where I hope we go with this bill. We'll see how it all shakes out.
Will the gentleman yield?
Sure.
I think the gentleman makes important points about those subsidies, but it's important to remember where those dollars come from. They come from the tax that is imposed by the bill. So we wouldn't want our fellow Americans thinking that the general revenue of the government is going to be dispersed through this. And while I'm not going to defend those provisions, I do think it's important to understand why they're there. Marijuana resulted in an entire generation of young black males being incarcerated, and there is resentment that it's resulting in a lot of white people getting rich right now. And that's what it is. And so that's why it's there. The gentleman can disagree with it, but also on the banking and the loans, there's also a rational basis for that. A lot of people who are in marijuana businesses can't access the normal US financial system. And so we have to create these like concierge programs because your banker in the 4th District of Ohio can't make those loans.
So we have to create a special program in the government to loan out money. And the idea that money is not fungible just doesn't make any sense. This is government money. The idea that, this is only from this, that does, we never use that argument anywhere else. It's all government money. Well, we should, but it's not how it works. We know
this government would run away. You and I like a lot more if we did that.
We know in practice that's not how it works. Money is fungible, and this is just more money in the hands of government to grow the cannabis business.
That's true.
Mr. Chairman, I yield back.
The gentleman yields back. For what purposes, Mr. Correa seek recognition?
Move to strike the last word, Mr. Chairman.
Gentleman is recognized.
Thank you very much, Mr. Chairman. I want to say to my colleagues, I really enjoyed this debate, this discussion on cannabis. You know, this morning I had a meeting with our VA Secretary, Veterans Affairs Secretary, to discuss this specific issue of cannabis as it refers to veterans. About 15 years ago, I used to chair the committee, State Senate Committee in California for Veterans Affairs, and I found out through a series of town halls that the big issue veterans had was their preference for cannabis over opioids to treat the invisible wounds that they had brought back from the battlefield, PTSD and other ailments. And it was interesting because when I asked our VA secretary, how can we have our veterans be provided with cannabis for treating their ailments, he said, I don't know. Said at the federal level, it's a class 1 drug. We don't know what we can and can't do. Yet at the same time, more than half the states, more than half the population in the United States lives under a jurisdiction where cannabis is legal. So we have a very convoluted, confused legal situation in the United States. Veterans, the folks that were in the battlefield, who put it all on the line to defend our country, want cannabis. Yet we at the federal level tell them if you use cannabis, you have broken the law. This is no way to treat our veterans. This is no way to run our country. California was the first state in the union to legalize cannabis way back in 1996. So far, we know cannabis is good for seizures, glaucoma, chronic pain, PTSD, and God knows what are the things it's good for. But we won't know until we do the medical research. And we cannot do medical research until cannabis is declassified at the federal level. Other nations like Israel, they actually export cannabis products. They actually export medical cannabis products to the rest of the world. Why do we not let America's free enterprise system take full advantage of the commercial benefits of cannabis and sell them not only in the US, but around the world? I ask my colleagues, let's get busy. Let's do the will of the people and pass the MORE Act. Mr. Chairman, I yield.
The gentleman yields back. For what purpose does Mr. Buck seek recognition?
Move to strike the last word.
Gentleman is recognized.
Mr. Chairman, this is one of those times where I wish we had had the opportunity to have some discussions before. I am in favor of moving forward in this in this particular area. I'm not in favor of this bill and can't co-sponsor this bill, and I want to just explain a few of my concerns to you. As a prosecutor, I entered into agreements, and I saw a number of my colleagues enter into agreements where a felon in possession of a gun that count would be dismissed, and we'd allow someone to plead to a possession of marijuana, or a possession with intent to distribute marijuana was pled down to possession of marijuana. Some very serious crimes have been dismissed as a result of allowing someone to plead to possession of marijuana. I have a problem with expunging and resentencing. I don't have a problem with giving judges the discretion to do that if they look at the record as a whole and understand what the original charges were and what the evidence was with those charges. But I have a problem with a wholesale expungement in that area. I also want to mention something to my colleague, Ms. Dean, in her comments about incarceration doesn't work. Incarceration does work. The one way you get a criminal, and I'm not suggesting cannabis at this point, but the one way you get someone who has become addicted to meth, has become addicted to heroin, off of that drug is you show them what the inside of a prison cell looks like. And you make them realize that they're going to be there for a long time if they keep using drugs and committing, and I'll yield in a moment, committing crimes related to that. And I'm talking about armed robberies and other things. And if that person sees the downside of continuing that lifestyle, they have much more incentive for a treatment program than simply offering them a treatment program.
Would the gentleman yield?
In a moment. I also want to talk about the tax. In Colorado, we have a tax on marijuana, and we also have a very heavy regulatory burden on marijuana. And it drives up the cost of marijuana. The result is that black market marijuana that comes in from Mexico, that comes in from folks that are growing marijuana in Colorado, undercut the marijuana that is being sold from dispensaries. And that means that you have marijuana from the dispensaries that don't have pesticides, that doesn't have herbicides, that is much healthier to consume, and you have black market marijuana that is unregulated. So a federal tax on marijuana is going to further increase the costs of marijuana and force people into the black market. My friend, Mr. Gates, mentioned the medicinal use of marijuana in Florida. Before we legalized marijuana in Colorado for recreational purposes, we legalized it for medicinal purposes, and amazingly, every single student at the University of Colorado had a lower back pain. It was a pandemic before COVID. It was amazing. And they took care of that lower back pain by getting a marijuana card and then using marijuana. So to legalize something for medicinal purposes, in my view, has not been terribly successful. And you mentioned tobacco and why should we have nicotine legal and marijuana illegal, I offer, for the record, an article from Tobacco 21 entitled Federal Tobacco 21, The Law of the Land. Congress recently passed a $1.37 trillion spending bill that included the provision to raise the minimum legal sales age for all tobacco products, and it gave the states grants to criminalize nicotine for anyone under the age of 21. So while the federal law doesn't include provisions that nicotine is illegal, the federal government has provided grants so that the states do provide.
Would the
Would the gentleman yield?
I got about 4 yields, and I only have 34 seconds to make 2 more. Really, I'm sure I'm gonna persuade you with these 2 points. But the my last point is, whenever you have a tax in the federal government, you need enforcement. If you have an income tax, you need the IRS. If you have an alcohol tax, you need ATF. And we're going to have some agency that is, and I don't believe for a moment that the tax will actually be able to take care of the grants as well as the enforcement mechanism. And I yield to whoever wants to address all those fine points.
The gentleman's time has expired, even though he didn't yield to me or anybody else. For what purposes, Mr. Cicilline seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I want to thank you for introducing this important bill that would directly impact the lives of thousands of Americans by removing marijuana from the federal controlled substances list. This enforcement of marijuana laws has been one of the major drivers of mass incarceration in the United States, has played a central role in our failed war on drugs. We arrest hundreds of thousands of people a year for marijuana-related charges, very often for mere possession. In 2018, as an example, we arrested more than 540,000 people for cannabis-related charges. In 2019, we arrested more people for cannabis-related charges, again, more than 500,000 people, than for violent crime. In 2020, even during a pandemic when crowded correctional facilities were a threat to health and safety, we imprisoned 40,000 people on marijuana-related charges. Our federal prison system is operating at 103% capacity, often with offenders in for nonviolent drug-related crimes. The consequences of a drug-related conviction can be devastating for the rest of the person's life, making it difficult or impossible to vote, getting a job or a loan, or qualifying for a government program. And as we know, these consequences have had a massively disproportionate impact on communities of color, including Black people, who are almost 4 times more likely than a white counterpart to be arrested for marijuana possession, as well as immigrants who can face dire immigration consequences for marijuana-related charges. This does not make sense for our community safety, the functioning of an effective prison system, and not for successful rehabilitation. I was a public defender and then a criminal defense lawyer, and I saw many people who were forced to be incarcerated for marijuana possession, and it's hard to forget the impact that it had on those people's lives who then, when they were released from prison, tried to get their records expunged so they could make some meaningful effort to reintegrate successfully into the community. It's time we start thinking smarter about our criminal justice system, and this important bill takes us in that direction. The MORE Act would remove marijuana from the list of substances controlled under the Controlled Substances Act, greatly reducing the number of marijuana-related arrests. It would also create numerous funding opportunities for individuals and communities most adversely impacted by the war on drugs, and provide for the expungement of federal cannabis arrests and offenses, among other important provisions. This bill is long overdue. I wholeheartedly support this important step in the right direction of reversing the failed war on drugs in this country. And I want to thank you again, Chairman Nadler, for your extraordinary leadership on this issue and on this piece of legislation. I'm proud to be a co-sponsor and to support it today, and just as proud to yield the balance of my time to the gentlelady from Pennsylvania, Ms. Dean.
I thank the gentleman from Rhode Island. And I did want to respond to the gentleman on the other side of the aisle who speaks from his prosecutorial past of nearly a decade ago. The conversation that you reveal shows 2 fundamental misunderstandings around addiction. It's a misunderstanding of the disease of addiction. Addiction is not a crime, it is literally a disease. And so when you say that the inside of a jail cell is an effective tool for recovery, it shows you don't understand that this is a disease. The inside of a jail cell has not been proven to be a recovery tool. The second thing that it reveals, your conversation reveals, is an old-time misunderstanding of the inequitable impact of criminalization of marijuana, the inequitable impact of those who are sitting in those jail cells. Seldom is it the white suburban kid, like maybe my own kid. Too often, it is inner city people of color, Black and brown, Hispanic people, and disproportionately people who are poor, who cannot afford recovery and cannot afford to be a part of the criminal justice system, only holding them back. Addiction, sir, is a disease. Incarcerating people and showing them the inside of a jail cell is not the path to recovery. And I yield back to the gentleman from Rhode Island.
I yield back, Mr. Chairman.
The gentleman yields back. For what purpose does Mr. Owen seek recognition?
I'd like to strike the last word.
Gentleman is recognized.
I would love to spend more time understanding the municipal benefits. I have a tendency of wanting to understand that and see if it might be something to be effective. My biggest concern is when I hear the federal government talk about going into business of targeting the Black community for the growing and selling of marijuana. But at the same time, the federal government has gone after every small business that I can think of, particularly Black small businesses. I'd like to take a few minutes, and I do this whenever I can. It's important to go back on our history. And we're acting as if the Black community has never been successful, that this whole thing of drugs is something we just have a tendency of drifting toward innately. Let me just give you a little history. When I was growing up, in the 40s, 50s, and 60s, the Black community led our country in the growth of the middle class, men matriculated from college, men committed to marriage, percentage of entrepreneurs. 40% of entrepreneurs equated to 50 to 60% of Black businesses, Black Americans across our country, not just Tallahassee, Florida, where I grew up, being part of the middle class. So I understand it's not hypothetical to me, the success of my community, when we're not on cloud nine. What I see is happening is the policies that have destroyed our family unit is exactly the reason why the tendency of going toward cloud nine is now looked at as a natural tendency for Black Americans. It's hopelessness that gets people into this process of drugs. We now have the highest dropout rate in our country, high school and college. We have the lowest business ownership, going from 40% now to 3.8%. And by the way, those who are trying to come out, build their businesses, they're burnt down every 4 years by Black Lives Matter and Antifa. We have men that cannot get jobs. Chicago, a few years ago, 93% of Black teens could not get a job. Now, where do they go? They're hopeless. They go to drugs. And then we build a society, economy for Black community in drugs. We need to look at our policies, my friends. No, we don't have a propensity to just go toward drugs. We want to hope to have the dreams everybody else does have. And we do that by giving people hope, giving them a chance to get a job. Just get rid of these labor unions that care more about adults than kids. And think about this, 75% of the Black boys in the state of California in 2017 cannot pass standard reading and writing tests, and we don't talk anything about that. We act as if it's natural. And then when they go into drugs and go into jail, we act as something not strange about that. I'd love to talk about, again, the municipal aspects of this. I think the fact that we can target the Black community and everybody who talks about the Black community is benefiting from these drugs being released, you got a problem. It's called soft bigotry of low expectations. It's time for us to stop that. Give us an opportunity to run our businesses, to build our families, put men back in the head of their families where they can be proud of who they are, with jobs. I will in a quick minute. With jobs, opportunities, hope, and I tell you what, we can pull ourselves out of this mess. We don't need the government to do it. We definitely don't need the government making special privileges for us to have these pot-building businesses in our communities. We don't need it unless you want to put it in every community. Hey, let's do that. Let's put it in Pelosi's community. And then I think I'll be all over it. I yield back.
Yeah. The gentleman.
I yield to.
Yeah, I grant the absolute accuracy of everything you said. Everything you said is true. But the effect of this bill will ameliorate it somewhat. I know from personal experience, when my son was in high school, a cop caught him distributing marijuana. And what did he do? He didn't arrest him. He brought him home to me and said, you know, your son is selling marijuana. If my son had been black, he would have arrested him. No question about it.
Can I get real back my time reclaimed? The difference is they had a dad for him to go home to have this conversation. In the black community, we don't have those dads. 70% of the black men in my community have been turned to whiners, weenies, and wimps, and they leave their families with no shame. So that's the problem right there.
I understand that, but this bill will simply it won't ameliorate the racial problem, but it will ameliorate somewhat because black kids who deal in pot are arrested at far greater rates than white kids who deal in pot because of prejudice by the police or whatever. This bill, by legalizing the pot and by expunging their records, will greatly help the black community. I yield back. The gentleman's time has expired. For what purpose does Ms. Jayapal seek recognition?
Mr. Chairman, I move to strike the last word.
The gentlelady is recognized.
Mr. Chairman, thank you for reintroducing this important bill, the Marijuana Opportunity Reinvestment and Expungement Act, to decriminalize cannabis across the country and enable states to make their own decisions about cannabis. Washington State, my home state, was the first state in the country to legalize cannabis in 2012. Our legalization in Washington has been a huge success. The licensed cannabis industry has generated over $1.1 billion in tax revenue for the state, and youth cannabis use has not markedly increased as some had feared. The people of Washington made this bold choice because we recognized that the war on drugs was a failure. People of color were bearing the brunt of that failure as they were disproportionately affected, arrested, and convicted for marijuana possession. But simply legalizing cannabis is not enough to address the disproportionate harm that criminalizing cannabis has inflicted on communities of color. That's why Washington State implemented the Marijuana Justice Initiative, which provides clemency relief to a few thousand eligible individuals who have one conviction for misdemeanor possession and allows individuals with multiple convictions to apply to vacate their record. Washington State also implemented the Marijuana Social Equity Program, which promotes cannabis business ownership in areas of high poverty or high enforcement of cannabis-related laws. These initiatives moved Washington in the direction of correcting injustices that disproportionately affected communities of color and created barriers to housing, employment, and education. I'm proud that the MORE Act will further many of these goals at the federal level. Despite Washington's overwhelming success, licensed cannabis retailers do not have access to the banking industry. Mr. Chairman, the room is not in order. The room is not in order. Thank you. Despite Washington's overwhelming success, licensed cannabis retailers do not have access to the banking industry and are thus unable to accept credit cards, deposit revenue into a bank account, or write checks. It creates a burden, particularly for small businesses, and means that legitimate licensed businesses are essentially acting as cash-only businesses. While the House of Representatives passed the Secure and Fair Enforcement Banking Act, the SAFE Act, back in April to ensure that the cannabis industry has access to banking, it is essential that Congress also address the racial disparities created through the war on drugs. And that is why, Mr. Chairman, I'm so proud that we are marking up this bill. This legislation would decriminalize cannabis at the federal level by removing the substance from the list of federally controlled substances. The legislation would require federal courts to expunge prior convictions, allow prior offenders to request expungement, and require courts on motion to conduct resentencing hearings for those still under supervision. In addition, it would invest in economic opportunity. It authorizes a 5% sales tax on cannabis and cannabis products to create an opportunity trust fund, which would provide resources to address the very needs of the communities that have been most seriously impacted by the war on drugs. This includes job training, legal aid, re-entry services, and an overall increase in the participation of minority communities in the growing cannabis market. Passing this legislation would be an important step forward to closing the gap between state and federal cannabis regulations and beginning to reconcile the damage caused by the war on drugs. I urge my colleagues to support this crucial bill, and I yield back the remainder of my time.
The gentlelady yields back. For what purpose? Does Mr. Bishop seek recognition?
To strike the last word.
Gentleman's recognized.
Thank you, Mr. Chairman. In a moment, I'm going to yield to the gentleman from Colorado so he can continue the exchange with Ms. Dean. And I don't know, Ms. Dean was here, I guess. She's not on video, is she? She was here a minute ago, right? I think she's left. I was interested, though, in that debate, and I'll throw it in there in case Mr. Buck wants to address it. I will say that overall, I hear all sorts of contradictions in the assurances we receive from those who were so confident about
Once we get them in, we'll never get them out.
legalization. I hear, that it's going to be a panacea for so many things. I hear pronounced echoes of the promises of a non-addictive opioids that would miraculously wipe away pain without addiction, always and everywhere. Didn't work out that way. We're seeing thousands and thousands of deaths every year from opioid addiction. I don't see liberalization as a good. I look forward to seeing if the advocates' predictions that widening drug use will be the salve that for what ails us is going to turn out to be true. But I noticed in one thing, Ms. Dean took on Mr. Buck as a prosecutor about the inside of a jail cell being inappropriate for addiction. But don't I always hear that marijuana is not addictive? Isn't that what they claim? So is there not a contradiction there? And with that, I yield to the gentleman from Colorado.
I thank the gentleman for yielding, and I just wanted to clarify something in my exchange with Ms. Dean. I am not suggesting for a moment that addicts should be put into jail cells or prison cells. What I am saying is, and there is a study out of Minnesota that showed that over 80% of the criminals incarcerated in the Minnesota prison system are addicts. They're not there because they're addicts. They're there because they committed very serious crimes to deal with their addiction, to pay for their addiction. They're there because they committed armed robbery. They're there because they committed burglaries. They're there because they committed crimes that they needed.
Yield?
Yes. Oh, I'm sorry.
I'll just for one sentence. Yeah. They're there for a lot of different crimes, but one of the crimes they're there for is for selling drugs, for selling marijuana. And that's what we think we ought to get rid of.
Well, it's another point, Mr. Chairman. I think there's something entirely different when we're talking about sympathy for people who've been who are subject to addiction, and then sympathy for people who are engaged in distributing drugs. Particularly, as an amendment I'm going to offer later, will make a point about this bill. Particularly drugs well beyond marijuana.
Mr. Bishop, will you yield for?
And so, well, before I do that, Mr. Cicilline, I wanted to make what I said about Ms. Dean's point earlier. She's returned to the dais and see if I can convert it from being rhetorical to something I could actually learn from. Again, Mr. Buck was talking about using marijuana possession and the prospect of the inside of a jail cell as a deterrent. And Ms. Dean, you responded with the proposition that this is addiction, but I thought we're talking about marijuana, and marijuana is not addicting according to those who are proponents. Isn't that right? If I didn't yield to the lady if she wishes to speak, but she does not. In that case, Mr. Cicilline, I yield to you.
No, I was just going to simply make the point, Mr. Bishop, that the circumstances in which people are incarcerated for having committed a crime, sadly, very often that comes as a result of an untreated addiction. And so I think the point that Ms. Dean was attempting to make was that we have to confront this as a public health crisis and provide effective treatment to deal with the illness of addiction. And by doing so, we will substantially reduce the likelihood that people will commit other crimes. So I think that was the point. We really do have to understand this as an addiction. Yes, of course.
Reclaiming my time, I hear it. The thread gets longer and longer since we were talking about marijuana, and now it's, we sort of abandoned that point. That it's a suggestion that it's not addictive, I guess. But or it's a long trail of thought to get to the point. But the other, and I had some other point here, and I think I've lost it. So it goes. Well, I can't recover it right now, so I'll yield back my time. Thank
you. The gentleman yields back. For what purpose does Ms. McBath seek recognition?
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady is recognized.
Thank you. And I'm really glad that we're continuing to have this policy discussion on cannabis. And, we've continued this from the 116th Congress. I hope we can find some resolutions. But I do want to say to my colleague, Mr. Owens, I really, really find the comment that you made about Black fathers not being in the homes in communities of color, I find that very insulting. There are many, many Black fathers that are in their homes caring for their families. But with that said, at this time, I'd like to yield the balance of my time to the gentlewoman from Texas, Sheila Jackson Lee.
Let me thank the gentlelady from Georgia, and particularly I want to thank her for carrying legislation that reinforces families and protects our children. Thank you, Congresswoman McBath, for your leadership in those areas and so important to our committee. Let me try for a moment with a sense of pause and dignity. First of all, I want to, as I give these numbers that reflect Hispanics and African Americans, let me also say that we have been seeing over the years the huge numbers of Americans, obviously, in the volunteer military, but over the years, the huge numbers of Hispanics and African Americans who've either been, if you will, drafted or have voluntarily joined forces, the United States military, the fire department, police and sheriffs. It is well documented. In my community, it is well documented. The prior chief of police from Houston was a Hispanic. The present chief of police is an African American. So I'm somewhat disturbed at the continued characterization of the George Floyd Justice and Policing Act as defunding police. I'd ask my colleague to read the large section on law enforcement, trust and integrity, funding to police, in fact, raising means of us explaining how important this legislation is. But let me indicate marijuana traffickers, through the U.S. Commission report, offenders have decreased by 67.3%. In fiscal year 2020, there were 1,181 marijuana traffic offenders. 62% of marijuana traffic offenders prosecuted in federal court in fiscal year 2020 were high Hispanic, 17.9%, Black, 14.9%, white, 5.2%. And then there were others, but there's a big number. 65.4% had little or no prior criminal history, but they were subject to incarceration. It tires me a little bit, my friends, for you to throw out the old, tired narrative of Democrats wanting to defund the police. It tires me to categorize us as anti-police. I don't like bringing up history, but it's so recent. Where were Republicans when on January 6th, those Trump supporters, Republicans and otherwise, were banging to death officers in blue? They weren't wearing red. They weren't wearing white. They were conspicuously officers attempting and doing and sacrificing their life. And all I could see in the video, which continues, it will be recorded until the earth ends, of individuals claiming the big lie and beating, breaking, cursing law enforcement officers. Can you take a ride down memory lane? Can you stop the tired narrative of saying who we are? We are Americans who honor law and order, and we honor justice and dignity. And we have mercy on those who have fallen before the bar and are thrown in the courts because we have not taken into consideration Schedule 1, I too understand the brain. It does not mature until 25. The
Gentleman
chairman
yield.
is right.
Gentleman
The
yield.
chairman is right. I will yield in a moment. The chairman is right. We must push against addiction. I'm a member of the Substance and Addiction Caucus, bipartisan. We will complement this legislation by working on programs. The social justice programs can be programs that educate people against drug use. And families who are two-family parents, Black and Hispanic, have seen the travails of addiction or drug trafficking because we live in neighborhoods of desperation in some instances. So, Mr. Chairman, I just want the record to be calmly the ability to deflect these narratives. I'm happy to yield to the gentleman. I don't know who it was.
The gentlelady's time is expired.
I was trying to be kind. I was trying to yield, my friend.
For what purpose does Mr. Biggs? For
Thanks.
what purpose does Mr. Biggs seek recognition?
Move strike last word.
Gentleman's recognized.
I'm just going to make one quick comment, then I'm going to yield to the ranker, and then I'll yield to Mr. Owens. The quote I found most intriguing of the last speaker was, quote, banging officers to death, close quote, on January 6th. I'd be interested to see the video that you've seen that I have not seen. I've requested 14,000 hours of video. There were no officers banged to death. I'll yield to the ranking member.
Republicans condemned the violence on January 6th. It would have been nice if Democrats in the summer of 2020, when law enforcement were being pelted with frozen bottles of water, if Democrats would have condemned that violence in the summer of 2020. Instead, what did they do? Raise money to bail those people out of jail. Here's the cities that have been defunded. The police have been defunded. Austin, Texas, $150 million. My guess is that city's controlled by Democrats. Baltimore, Maryland, $22 million cut of police. My guess is that city's controlled by Democrats. Boston, Massachusetts, $12 million. Minneapolis, $8 million cut to the police. Don't give me all that garbage that we just heard. We know the facts. We condemn violence every time it happens. Every single time. Not from the other side. I yield back to my friend from Arizona.
I thank the gentleman. I'll yield to the gentleman from Utah, Mr. Owens.
Thank you so much. I'd like to address comments made by my friend from Georgia on the other side. I think if we're going to ever get to resolving the issues we're having in the Black community, we got to be honest, my friends. We just heard that a pushback on the fact that we're getting Black men in the Black community not doing their job. Well, let me give you the facts real quick. First of all, when I was growing up in the 60s, we led the country in men committed to marriage, over 70%. Black women could rely on getting married more than white women until 1970. We now have between 70 to 80% of Black fathers who desert their families, and we're not willing to be honest about that. We're not willing to say that these guys need to man up. Maybe when we start telling our kids that they're being nothing but whiners, weenies, and wimps if men cannot take care of their own kids, that might be a good start.
I reject the words
Well,
of
let
this
me
gentleman.
please.
Mr. Chairman, I call for order.
Reject the words
I
of
call
this
for
gentleman.
order.
We right now, the facts are in.
Mr. Biggs has the time.
The facts are in. Facts. Black fathers, 70 to 80% are deserting their families. You talk to these Black single women out there and see what they think about this. We sit in this little bubble where we're living the life, we're married, many of us, and we cannot be honest about what's happening in our urban communities. While these kids are growing up with no fathers, no example.
Solutions?
At the end of the day, there's a reason why our kids are being led toward these options of hopelessness. And for us to sit here in 2021, no, not right now, I'm sorry, let me just finish. To sit here in 2021 and not point out the fact that we have fatherless homes. We have 70 to 80%. These are the facts, my friends. 70 to 80% will not marry the mothers of their children, and instead will probably try to convince them so that to dissolve them from their issues to go and get an abortion. We've lost 20 million Black babies over the last 40 years. 40% of my race has been exterminated because we don't have men that'll sit there and say, I'll take care of my kids, I'll protect my child, I'll make sure they grow up and get a good education, I'll make sure they're protected in my home, and not leave it to their mother to do it on their own. And if we can't be honest about that, how in the world are we going to ever get this thing taken care of? I'll tell you what, you're going to start seeing black men, that 30% that's still left, the really good, solid fathers, we're standing up. We're changing this trajectory. We're sick and tired of people looking at us as this is a normal thing that we just don't do our job as men. Be aware, we're waking up. And that's going to be a change in the coming years that we're going to start seeing black men really commit to their families, their kids, the mothers of their children, and being the productive Americans we were back when I was growing up. I yield back.
I'll yield to the gentleman from Texas, Mr. Roy.
Sorry about that. I had to get on off mute. I appreciate the gentleman from Arizona. I think there's only about 20 seconds left. All I wanted to say is I co-sponsor the remarks from the gentleman from Utah. And I would just simply suggest that going down this road of focusing in, as my colleagues on the other side of the aisle want to do, on January 6th, somehow suggest that our commitment to wanting to believe that we should stand with law enforcement and then to completely ignore what occurred across our country when cities and streets were burning
The time of the gentleman has expired.
Is completely absurd. And I yield back.
For what purpose does Mr. Tiffany seek recognition?
Thank you, Mr. Chairman. I have an amendment at the desk.
The clerk will report the amendment.
Mr. Chairman, I reserve a point of order.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 3617, offered by Mr. Tiffany of Wisconsin, page 65.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. My amendment prohibits certain groups from benefiting from the grants proposed in the MORE Act. The MORE Act contains many flaws, but we can all agree that individuals who have been convicted of dealing drugs to minors should not benefit from taxpayer dollars. We should also agree that anyone convicted of rioting, looting, or property destruction should also be prohibited from benefiting from these grants. Some estimates put the financial losses from the riots at $2 billion and dozens of lives lost, including heroic law enforcement officers. The loss of life is an insurmountable catastrophic cost. This committee should stand together and stand firm in upholding the rule of law. In June of 2020, in my home state of Wisconsin, violent rioters in Madison assaulted a Democrat state senator for taking a picture of them. They defaced and destroyed the statue of Hans Christian Heg, an immigrant, an advocate for prison reform, and the leader of the abolitionist movement. They tore down the Forward statue, a monument to the progress of women, by the way. Wisconsin was the first state to ratify women's suffrage a century ago. That same night, they attempted to storm and breach the Capitol building. In Milwaukee, the violence and rioting were so extreme that the police department advised residents to stay at home and away from windows because the rioters were attacking homes and smashing storefronts. Videos of these events show that some rioters were heavily armed. These are not peaceful protests, as many claimed. I urge all my colleagues to support this common sense amendment that prohibits individuals convicted of rioting, looting, or property destruction from receiving services from these federal grant services. Let's stop endorsing and rewarding people who blatantly disregard our laws. I yield back, Mr. Chairman.
The gentleman yields back. I recognize myself in opposition to the amendment. The funding under the grants in this bill are critical to addressing the harmful impact of the enforcement of marijuana laws. I do not support conditioning these funds, which would only serve to undermine these critical restorative portions of the bill. Therefore, I urge my colleagues to join me in opposing this amendment. I yield back. Who seeks recognition?
Mr. Chairman.
Who's that? For what purpose does Ms. Deming seek recognition?
I move to strike the last word.
The gentlelady is recognized.
Mr. Chairman, thank you. I have listened to the very spirited discussion and tried my best to not say a word and to move forward with passing or not passing this legislation out of committee.
but I have just been saddened and disappointed at the discussion that I have had. This is a critical moment in our history, and we're dealing with some serious issues. And as we discuss whether we want to support the MORE Act or not, I struggle with it too, because we've seen some pretty bizarre behavior and some bizarre statements, many of them coming out of this session of the House of Representatives. And I wonder, do we really want to send any signal that we support introducing yet another mind-altering substance into society? But when I sit here as the daughter of a janitor, black man in the South, who went to work 7 days a week to make ends meet for our family. As I sit here as the sister of 3 black men, Mr. Owens, who provided for their family. I'm married to a black man who provides for his family. To suggest that what we decide to do with this legislation is somehow the responsibility of black men in America. Mr. Chairman, the gentleman's statements were insulting to every black man who does provide. And to suggest that black men are the only people who he believes doesn't take care of their families, I think that is an all-time low. But the other side has talked about the increase in violent crime, the murder rate. And I do believe that our time would be much better spent if we asked law enforcement officers what would they like Congress to do to support them in their efforts to reduce violent crime, cut the murder rate. I don't think they would say, well, please don't support the MORE Act. I think there are other ways, if we are truly committed and not wanting to use law enforcement as political pawns, there are a lot of ways that we can support the good men and women in blue in their efforts to reduce violent crime. But the bottom line is, regardless of what our personal beliefs are, several states, many of the members in this committee are from those states, have already moved forward with legalization of cannabis in some form or another. And as I sit here as a police chief, I do not believe that the federal government, in this case, dealing with marijuana, should have legislation that supersedes what the states want to do and what the states think is best. So as we have this friendly debate, I really think that we can do a lot better trying to understand addiction. I understand it. Trying to understand that visiting a prison cell does not work in keeping people from committing crimes. Maybe it worked 50 years ago. I can tell you, as a career law enforcement officer, it no longer works. And I think we should get serious about addressing the critical issues of the American people. And just by the way, Mr. Tiffany, there are already laws on the book that deal with looters and rioters. Thank you for the time, Mr. Chairman.
Yield?
I yield back to the chairman.
Gentlelady yield? The gentlelady yield?
I yield to Ms. Jackson-Lee.
I thank the gentlelady. I just want to comment on the point, being the chair of the subcommittee. These are viable issues that shows our commitment to the American people. And that is, of course, being problem solvers for our law enforcement officers. And you are right, the surge of homicide, murders, domestic violence, gun violence would be appropriate topics to partner with and ask how best to be able to solve those problems. Let me say how pleased I am that we have $2 billion for community violence intervention, which will not be done alone. It is dollars and programs that we can collaborate with law enforcement. That is clearly important. Finally, just simply say that let us uphold black men, black women, and black families. Let's uphold American families, as you have said, rather than using stereotypes to ensure that we don't uphold them, but we tear them apart. Thank you for yielding.
Gentleman's time The gentlelady's time has expired. For what purpose does Mr. Owen seek recognition?
I'd like to strike the last word.
The gentleman is recognized.
You know, it's interesting. I can now see why there's so much frustration throughout our country, particularly in Black communities, of why things are not changing. My community is suffering. Drugs, abandonment, child trafficking, single women trying to make it on their own because they have men who will not man up and do their job. And we sit here in this chamber and act that that's normal. The facts are very simply this. Only 38% of Black children have both husband and moms and dad in their home. You know what? I was raised by a remarkable community. I was raised by a community that led our country in commitment of men to marriage, men to their kids. And they showed them how to be educated, how to man up, how to be courageous, how to have principle. It was the age of Martin Luther King, when you saw men walking into danger, knowing it was going to come, but yet being disciplined because they understood that they were there for a legacy. What is our legacy today? We have a Congress here that will not even acknowledge that we have men that are not manning up. That 70% of our Black fathers, quote, are deserting their mothers, and there's nothing, they're conflating that with other Black men. And I reject it. I reject it with everything I have. We have good men out there working hard to take care of their families, but we have, unfortunately, too many men that are not. And until we recognize that, we're not going to get any changes. Until we start telling these whiners, weenies, and wimps who will not stand up for their families to man up, that we will not be considered a good member of our society. That's the way I was raised. If we had these kind of guys in my community, they'll be told right off the bat, we have no respect for you. Instead, we are telling these people who will not stand up for their families, welcome, no big deal, keep it up. It's time for us to stop that. Let's not conflate good Black men who are going to be changing our society, who are going to be working from inside out, not waiting for government, by the way, to do it. You wait and watch, see the next few years. We have good Black men who are going to stand up, and we're going to show these whiners, weenies, and wimps, do something else, go somewhere else. Don't come to my community and think that you're going to be respected, because you're not if you don't stand up for your kids. Marry the mother of your children and take care of them all. Leave a legacy where you have a good name behind you. Not what we're talking about today, in which we have people literally trying to say that we don't have this problem. Are you serious? Our problem is a lack of good men. It's time for us to change it by recognizing, number one, and if all these good men out there, you keep it up. All you single ladies out there trying to make it, raise your standards, my friends. Let's find good men so they can take care of your kids. And the good men will rise themselves up to be respected by you. So I yield back.
The gentleman yields back. Does anyone else seek recognition? Mr. Roy?
Move to strike the last
What
word.
purpose does Ms. Garcia seek recognition?
I move to strike the last word. And
Gentlelady's recognized.
I just want to say that I am just really offended by some of the comments that are being made. I graduated from law school from a historically Black college, and I admit many good Black men. And Houston has many good Black men. So I'm not sure what this is about and what it has to do with this bill, but I do yield the remainder of my time to my colleague from Houston, Sheila Jackson-Lee.
I too don't understand what it's about. And I just want to say to Mr. Owens, I can't stop you, and I know that we're on the MORE Act. I'm sorry, Mr. Chairman, but I cannot stop you from your own views, but you don't seem to even understand about the platform from which you speak. Your words are now going to spread across America, not with some of the underbelly of your comments, which is Black men are going to get together. It's going to get out as Black men are not worth a cup, and I won't finish the sentence. This is not the role of people of prominence and leadership and governance, because the problems of fatherhood prevail throughout society, no matter what race you come from. But what you will say and what credibility you give will be the consistent stereotypes. But yet you will not acknowledge, because when I finish, you will get time to diminish the issue of race and racism. And Black men have been the brunt of race and racism. I know it. My father, an outstanding artist, worked on Madison Avenue. But when the artist returned back from World War II, he worked with a tin cup, not on Madison Avenue. But yet he worked at every aspect to support us. And there are today in 2021, individuals who, for whatever reason, have never been able to get a college education, community college education. And yes, I am not in any way condoning bad actors. But in my community, I've seen mom and dad poor and together. Poor and together. And they're in their 20s and 30s. I don't like the violence, but it plagues our society. We cannot attribute it. Let's talk about the MORE Act for its law enforcement impact, its life-saving impact, its impact to end mass incarceration. But you sit on this podium and use this place to condemn innocent human beings. They're not going to say when they walk down the street, oh, the congressperson was getting this gentleman walking or this person looking the way they look, but they weren't trying to get this one going into the church building. They're going to label everyone Black man in the same way. Don't do that to us. And fail to acknowledge that they were denied the basic rights. Did they get the GI Bill, sir? No, they did not when they came back from World War II. Did they ride on the back of the train when they came back? Did most of them lose their life in Vietnam? Huge numbers of Black men lost their life in Vietnam when the draft was going on. Huge numbers, along with others. So I'm just saying, we have worked together on the crime subcommittee. We're working together on juvenile justice. You just don't realize the impact. And then you play into your colleagues who believe that we are unequal anyhow. And you call us whiners and whimpers, Black men who have been denied jobs, as along with Black women. There is a question of family in America. And we should work collectively to promote family as a concept. But as you well know, families can be single fathers, they can be single mothers, they can be grandmothers, they can be aunts and uncles, they can be godmothers and godfathers. We don't have the standard family concept that many of us had. But I respect the fact that sometimes what people have to overcome leads them to some of the travails that we're talking about. Government can't answer everything, but we can be a partner. And the positive elements of this legislation says, let's be a partner in social justice or moving away from the inequities in communities. Let's stop the incarceration and put them in job training or rehabilitation. But I will not let you suggest that there are not kings and queens in our community and Frederick Douglass and Martin King and John Lewis don't exist.
The gentlelady's time has expired.
I will not have it.
Mr.
Now, whatever you come back with,
Chairman.
I will not have it. I yield back, Mr. Chairman. Thank you. Thank you. I thank you to the gentlelady.
Mr. Chairman.
Gentlelady's time has expired.
Mr. Chairman.
For what purposes, Mr. Jordan seek
Move
recognition?
to strike the last word.
Gentleman is
Yield
recognized.
to the gentleman from Utah.
First of all, I'm thankful for this opportunity, and I hope the entire country and world listens to this conversation. Any man who will not provide for his family, I don't care what color, it just happens 70% of ours is Black, will not provide for his family, will not take care of his kids, will not leave a legacy or good name, and a wife that feels protected and proud is a whiner, weenie, and a wimp, period. And we have too many of them in the Black community today. Why? Because of Democratic policies. Policies that give us welfare on government. Policies that make sure our kids don't get a chance to get a job. Policies that make sure that our kids, 75% of them in California, cannot read and write. Policies that say, let's put them on cloud 9 instead of giving them an opportunity to think and be proud of who they are. My dad came back from World War II, could not get a postgraduate degree because of Jim Crow laws in Texas. ran across a box of letters of rejection letters. You know what those guys did, another generation? They used that as motivation. He went up to Ohio State, got his PhD. It was a janitor there for a semester because he ran out of money. Went on to 40 years as a college professor, a big, super successful entrepreneur, traveled the world. He had a brother who got his PhD at Ohio State in economics, college professor for 40 years, super successful entrepreneur, traveled the world. An older brother, his engineer, who decided he was going to do a part-time business. So in 1960, when people didn't do that kind of stuff, he bought a little plane and traveled from Wichita Falls, Texas to Chicago carrying mail. That was the generation I grew up around. They weren't sorry, they weren't feeling. Matter of fact, you tell them, what we're telling our kids today, that they're hapless and hopeless because they're black, they would fight you. They looked at that as an insult, that they were looked at as being less than anybody else. And today we embrace it. We can't wait to tell everybody the next victimhood that we're going to be part of because of our color, because of what happened 200 years ago. Who cares about 200 years ago when today we have the opportunity to make a decision today to succeed? By the way, that's what any successful person does, in case you don't know. I don't care what color it is. You try, you risk, you get back up, and you go again. That's the American way. And we were doing it, and now we're defending these people, these men, who will not take care of their families, conflating that with other good men who are. My message very simply is this. We're having a conversation that is well overdue. And I'm thankful, thank goodness, that America has a chance to see the different perception of black men. I'm saying very simply, men are men. They take care of their family. If you're not, don't call yourself one. And I don't care what color you are. It's time for us to start putting these people in place. If you cannot take care of people you're responsible for, do something else. Don't call yourself a man, please. And for you black men out there, this is our opportunity, my friends. We now understand, if we're going to make this thing happen, let's go back to the old-fashioned way. What did it take? Faith, family, the free market, and education. Let's make sure every policy we pass deals with faith, family, free market, and education. And we will do exactly what the generation before us did. We'll lead in every category we can possibly lead in, because we're doing it the right way, doing it the American way. And it's time for us to show the difference in those who don't see us, our black men, as being capable of doing the right thing. If our expectations are so low that we call these guys who are bad actors and we want to conflate them with good people, if that's what the standard is, let's find another ideology to follow, another party to follow, because that's not the way, that's the way my parents were taught us. I yield back.
Mr. Chairman.
Gentleman yields back. For what purposes Mr. Cicilline seek recognition?
I move to strike the last word.
Gentleman is recognized.
I want to say that I like Congresswoman Demings and Congresswoman Jackson Lee and Congresswoman Sylvia. I'm deeply disturbed by some of these arguments being advanced today. And I want to say I consider Mr. Owens my friend. I gave him a book, Color of Law, as a gift that chronicles the serious discrimination against black folks in this country for a very, very long time, that showed that the crushing impact of that discrimination is alive and well today. And I would ask for unanimous consent to introduce into the record an article from the New York Times entitled, "Extensive Data Shows Punishing Reach of Race for Black Boys," on May 19th of 2018.
Without objection.
I'd also like to bring your attention to an article called "The Truth About Black Fatherhood, Stereotypes About Black Fathers," and I'm going to use some of my time to read from it. The stereotype of black fathers as absent and black children as fatherless, first introduced over 50 years ago, has, like many racial stereotypes, refused to die. The article goes on to say that, in fact, the idea that racial disparities in education, employment, income, incarceration, and more can be blamed not on structural racism, but on this, quote, absence of black fathers, has been parroted by pundits and politicians alike. Even black public figures have shared these statistics. And they go on to say, this stereotype ignores clear evidence that black fathers are in fact more involved in their children's care and their lives than fathers of other races. We cannot equate the number of unmarried dads to the number of fatherless children. First of all, marriage rates don't necessarily reflect the number of black fathers living with their children. As writer Josh Lewis points out, the majority of black dads, 2.5 million of around 4.2 million, do live with their kids, even if they're not married to their partner. And second, according to a 2013 report by the CDC, black dads, whether they live with their children or not, are more actively involved in their children's lives than their counterparts of other races. For example, the CDC reports that black fathers who live with their children are more likely than fathers of other races to provide physical care, bathe, diaper, and feed for their young children, read to their children, and help their children with their homework, all on a daily basis, than fathers of other races who cohabitate with their kids. The report also reveals that among dads who don't live with their children, black dads are more likely to be involved in care, including reading to their children, helping them with their homework, talking to them about their days, and taking them to activities than Hispanic or white dads who live apart from their kids. This is some research I just found. So this notion of this sort of general claim about the behavior of black dads is both empirically inaccurate and unhelpful. And what we ought to be focusing on is how do we lift people up? How do we lift up families? How do we affirm the work that dads who do the right things of whatever race? And so I stand with my colleagues who have both saying we should avoid these kinds of generalizations and look below these numbers to find out about the meaningful engagement of folks and recognize the very damaging and real consequences of historic and institutional racism in this country that make it so much harder for certain members of our community to provide the kind of care and guidance that we all expect from those who are parents of whatever race. So I just think this is an area where it's important we really understand context and understand our history and understand, as Sheila Jackson Lee said, the important role we play as members of Congress to use our position of leadership to lift people up, to affirm and support people who endeavor to do the right thing in their families, in their communities, in this country. And with that, I yield back.
The gentleman yields back for what purpose is Mr. Royce recognition.
Move to strike the last word.
Gentleman's recognized.
Thank the chairman. I want to thank the gentleman from Utah for his important comments that I am glad there are hopefully millions of Americans who will be able to see, certainly not live, but hopefully by clips that are distributed around and in the news. And I would just note that this is all relevant. People say we're just kind of going down some rabbit trail here when we're talking about the MORE Act. And as I noted earlier when we were talking about that, this isn't simply just a debate about descheduling, which I think is a reasonable debate to have. I wouldn't deschedule it, but I'd certainly have a discussion about how to change or think about how we handle possession and those kinds of things. But I've already spoken on that. What I would say is that, again, the bill goes well beyond that.
One moment, sir, and stop the clock.
Yeah.
I just want to stop the clock where it was, not.
Thank you, Chairman.
I would remind some of my colleagues that they should wear masks in the room. Okay. Gentleman is re-recognized.
I appreciate that. I'll recognize I probably have something south of 5 minutes, but that's fine. I'll try to keep it shorter. But I would just say to the chairman that what I was saying is, if we're having just a straight up debate about the descheduling, all right, fine. I think we can have a robust debate about that. And there might be even more bipartisan agreement. But we've got a bill here that creates an office of cannabis, whatever it is, justice, and it goes through funding and grant programs and creation, and by my colleagues on the other side of the aisle's own words, creation of jobs and a whole infrastructure around job creation through this government efforting with respect to pot. And this is a just philosophical disagreement. And I'm happy to yield to the gentleman from Utah if he has anything else to add. He's been eloquent about this, but we're now 50 years plus, 60 years really, into the, quote, war on poverty. Now, I represent Johnson City. I represent part of Austin and LBJ. somewhat famously came from my neck of the woods. And we've spent $22 trillion in the war on poverty, and the poverty rates are effectively the same. We've spent $22 trillion on the war on poverty and the quote unquote great society, of which there was nothing great about it. When my colleague from Utah is properly raising the questions about taking the family rates with respect to Black Americans and what that means with respect to having two parents in a household and who's being raised with two parents in a household. These are just simple facts. And frankly, they cut across racial lines. All right, we'll take race out of it for a minute, but we have utterly destroyed the concept of having two parents and children in a family home with two parents. And that's a statement that has nothing to do with race, okay? Unwed birth rates from 1945 to 2012 went from 5% to now almost 50%. We're at almost 45%, I think maybe 50%. That is disastrous. And that took off in the 1960s with the massive expansion of the welfare state. And so what I oppose—
The time of the gentleman has expired.
That was 5 minutes?
Yeah, it was more than 5 minutes.
Nah, I don't know about that.
For what? Does anyone else seek recognition? There are no further speakers. The question occurs on the amendment. All in favor of the amendment will say aye. Aye. Opposed, no. No.
No.
In the opinion of the chair, the noes have it.
I will ask for a recorded
Roll call vote is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson-Lee?
No.
Ms. Jackson-Lee votes no. Mr. Cohen? Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass?
Bass votes no.
Ms. Bass votes no. Mr. Jeffries? Mr. Cicilline?
No.
Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Raskin? Ms. Jayapal? Ms. Stimmings? Ms. Stimmings votes no. Mr. Correa?
No.
Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia? Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath?
No.
Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean? Ms. Dean votes no. Ms. Escobar? Mr. Jones?
Come in.
Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush? Mr. Jordan?
How is Swalwell recorded?
Mr. Jordan votes yes. Mr. Swalwell, you were not recorded.
No.
Mr. Swalwell votes no. Mr. Shabbat?
Aye.
Mr. Shabbat votes aye. Mr. Gomert?
Mr. Swalwell, oh yeah, he keeps jumping in. Mr. Gomer votes yes.
Mr. Gomert votes yes. Mr. Issa?
Yes.
Mr. Issa votes yes. Mr. Buck? Mr. Gates? Mr. Johnson of Louisiana? Mr. Biggs?
Aye.
Mr. Biggs votes aye. Mr. McClintock? Mr. Stube,
Yes.
Mr. Stube votes yes. Mr. Tiffany,
Mr. Chairman, I would ask that you request everyone have the courtesy to wait until the roll call is done if you're not there when your name is called. I vote aye.
Mr. Tiffany votes aye. Mr. Massey,
Aye.
Mr. Massey votes aye. Mr. Roy,
Aye.
Mr. Roy votes aye. Mr. Bishop, Mr. Bishop votes aye. Ms. Fishbach,
Aye.
Ms. Fishbach votes aye. Ms. Sparts,
Yes.
Ms. Sparts votes yes. Mr. Fitzgerald, Mr. Fitzgerald votes aye. Mr. Benz,
Aye.
Mr. Benz votes aye. Mr. Owens,
Yes.
Mr. Owens votes aye.
Am I recorded? This is Dr. Cohen.
Mr. Cohen, you are not recorded.
I'd like to vote aye. Is this on the amendment?
Yes.
I vote no.
Mr. Cohen votes no.
I would request.
How am I recorded?
Mr. Liu, you are not recorded.
No.
Mr. Liu votes no.
Are there any other members who wish to vote who haven't voted?
Ms. Jackson Lee, you are recorded as no.
Are there any other members who wish to be recorded who haven't been recorded?
Mr. Chairman, how am I recorded?
Mr. Deutsch, you are not recorded.
No.
Mr. Deutsch votes no.
Clerk will report.
Mr. Chairman, there are 15 ayes and 19 noes.
The amendment is not agreed to. Are there any further amendments to the amendment nature of a substitute? For what purpose does Mr. Fitzgerald seek recognition?
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment-
Chairman, I reserve a point of order.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 3617, offered by Mr. Fitzgerald of Wisconsin. Page 64, line 19, strike minor and insert minor.
With that, the amendment will be considered as read, and the gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. I don't like this bill. After a number of years in the state legislature in Wisconsin, and with Wisconsin still being a state that has not legalized marijuana, I was always perplexed by the idea that state by state it looked like, and then ultimately
I'm back.
now a discussion about the entire country somehow decriminalizing and legalizing marijuana. Made no sense at a time when you have the massive struggle, and we're seeing it in Wisconsin too, and believe it or not, there's a line, it's called Highway 29, where right now we still struggle to control the scourge of Oxycontin on our society. And north of Highway 29, it's for whatever reason, law enforcement says there's more meth coming in from the western states. And at the same time, we're considering opening the door and widening the access of another controlled substance and saying it will do no harm. My wife's been an AODA counselor as well as a middle school, high school counselor for over 30 years. And I'm not worried about the hippie smoking pot at home. But she says if you want to watch a 7th grader completely unwind, who's a good student and on track, it's pretty easy to predict when it happens. It's when they get access to controlled substances from the older kids in the same school. And I don't know why we don't look at that as the real danger of getting access to marijuana and to other controlled substances. There's some other things in the bill that I don't think there's a nexus for, and that's what the amendment before us today is. The MORE Act allows the Director of Cannabis Justice Office to make grants to entities that provide substance use disorder services. And the bill, however, prohibits individuals who have been convicted of dealing drugs to children from receiving services paid for by these grants. Like I said, I don't like the bill, but I agree that criminals who deal dangerous drugs to our children should not be the beneficiaries of a federal grant program. And Congress has made the decision many, many times that in our criminal code, there should be enhanced penalties for people who traffic drugs. And I agree, everybody agrees. But the enhanced penalties apply to people who possess firearms too. It's just one of these, like I said, a nexus in this bill that makes no sense and that it's not addressed. This amendment would do that. We shouldn't be allowing taxpayer dollars to flow to people who engage in drug trafficking, who are incarcerated, arrested and then incarcerated for possession of a firearm. This amendment would address that. I think it's common sense, something that everybody probably agrees on, that there is a reason for that, and it's because guns and drug dealing end in tragic results all too often. And I would urge my colleagues to support this amendment. I yield back.
The gentleman yields back. I want to remind members to wear their masks except when speaking. This amendment is very similar to the previous amendment, and most of the same arguments apply. And I oppose this amendment for the same reason. The funding provided under the grants in this bill is critical to addressing the harmful impacts of the enforcement of marijuana laws. I do not support conditioning these funds or limiting their application, which would only serve to undermine these critical restorative portions of the bill. Therefore, I urge my colleague to join me in opposing this amendment. I yield back. Does anyone else seek recognition? If not, the question occurs on the amendment. All in favor say aye.
Aye.
Opposed, no. No.
No.
The noes have it.
Request the yeas and the nays.
Yeas and nays are requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren? Ms. Jackson-Lee? Ms. Jackson-Lee votes no. Mr. Cohen?
No.
Mr. Cohen votes no. Mr. Johnson of Georgia? Mr. Johnson of Georgia?
Johnson of Georgia votes no.
Mr. Johnson of Georgia votes no. Mr. Deutsch?
No.
Mr. Deutsch votes no. Ms. Bass?
No.
Ms. Bass votes no. Mr. Jeffries? Mr. Cicilline?
No.
Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal? Ms. Stimmings? Ms. Demmings votes no. Mr. Correa?
No.
Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia? Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath?
No.
Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean? Ms. Dean votes no. Ms. Escobar? Mr. Jones? Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush?
How is Swalwell recorded?
Mr. Swalwell, you are not recorded.
No.
Members will please wait until the roll call is completed.
Mr. Swalwell votes no. Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Shabbat?
Aye.
Mr. Shabbat votes aye. Mr. Gomert?
Aye.
Mr. Gomert votes aye. Mr. Issa? Mr. Issa votes aye. Mr. Buck? Mr. Gates? Mr. Johnson of Louisiana? Mr. Biggs?
Aye.
Mr. Biggs votes aye. Mr. McClintock?
Well, I'm curious on how Mr. Swalwell is recorded.
Mr. Swalwell is recorded as no.
Oh, thank you. Aye.
Mr. McClintock votes aye. Mr. Stubbe?
Yes.
Mr. Stubbe votes yes. Mr. Tiffany?
Aye.
Mr. Tiffany votes aye. Mr. Massey?
Aye.
Mr. Massey votes aye. Mr. Roy?
Aye.
Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes aye. Ms. Fishbach?
Aye.
Ms. Fishbach votes aye. Ms. Sparts? Mr. Fitzgerald?
Aye.
Mr. Fitzgerald votes aye. Mr. Benz?
Yes.
Mr. Benz votes yes. Mr. Owens? Mr. Owens votes aye.
How is Lofgren recorded?
Ms. Lofgren, you are not recorded.
No.
Ms. Lofgren votes no.
Are there any other members who wish to be recorded who haven't been recorded? If not, the clerk will report.
Mr. Chairman, there are 15 ayes and 20 noes.
The amendment is not agreed to. Are there any further amendments to the amendment in the nature of a substitute? For what purposes Mr. Fitzgerald seek recognition? The clerk will report the amendment. Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 3617, offered by Mr. Fitzgerald, page 68, line 7, strike reports.
Without objection, the amendment is considered as read, and the gentleman is recognized in support of his amendment for 5 minutes.
Thank you, Mr. Chairman. My amendment would simply change one word in the bill. It would change the word reports to has in the definition of individuals adversely impacted by the war on drugs. This amendment would ensure that tax cheats are not able to take advantage of a grant program enacted through this legislation. Somebody who cheated on their taxes. One of the stated goals of President Biden's Build Back Better agenda is to ensure that everyone pays their fair share on taxes, even if the president hasn't. Those who are not, did you catch that? I don't know. Those who are not paying their fair share should not benefit from taxpayer-funded grants to sell cannabis. I urge my colleagues to support this amendment to prevent tax cheats from unjustly gaining access to federal funds. I yield back.
The gentleman yields back. I recognize myself in opposition. there's no reason to make this change. Because individuals are expected to report truthfully in any event, so this change doesn't, this amendment doesn't do anything. And for that reason, I oppose the amendment. I yield back.
Mr. Chairman?
Does anyone else seek recognition?
Mr. Chairman, strike last word.
For, who said that?
Right here, I'm sorry.
For what purpose does Mr. Jordan seek recognition?
But I thought this language, am I
For what
mistaken?
purpose does Mr. Jordan
Strike the
seek
last word.
recognition? The gentleman is recognized.
Yeah, I thought this language was in the bill you all introduced last session. Nothing new. It's newer, better version, I guess, maybe. Or maybe something else changed or caused you to want to take this language out. What could that be? I yield back.
The gentleman yields back. The question occurs on the amendment. All in favor of the amendment, say aye.
Aye.
Opposed, no. No.
No.
In the opinion of the chair, the noes have it.
Mr. Chair, can I get the yeas and nays on
The
that?
yeas and nays are requested. The clerk will call the roll.
Mr. Nadler.
No.
Mr. Nadler votes no. Ms. Lofgren.
No.
Ms. Lofgren votes no. Ms. Jackson-Lee. Ms. Jackson-Lee votes no. Mr. Cohen.
No.
Mr. Cohen votes no. Mr. Johnson of Georgia.
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch.
No.
Mr. Deutsch votes no. Ms. Bass.
No.
Ms. Bass votes no. Mr. Jeffries. Mr. Cicilline. Mr. Cicilline votes no. Mr. Swalwell.
No.
Mr. Swalwell votes no. Mr. Liu.
No.
Mr. Liu, you'll have to turn your camera on.
No.
Mr. Liu votes no. Mr. Raskin. Ms. Jayapal. Ms. Stimmings. Ms. Stimmings votes no. Mr. Correa.
No.
Mr. Correa votes no.
Oh.
Ms. Scanlon.
No.
Ms. Scanlon votes no. Ms. Garcia. Ms. Garcia votes no. Mr. Neguse.
No.
Mr. Neguse votes no. Ms. McBath.
No.
Ms. McBath votes no. Mr. Stanton.
No.
Mr. Stanton votes no. Ms. Dean.
No.
Ms. Dean votes no. Ms. Escobar. Mr. Jones. Ms. Ross.
Ross votes no.
Ms. Ross votes no. Ms. Bush. Mr. Jordan. Yes. Mr. Jordan votes yes. Mr. Shabbat.
Aye.
Mr. Shabbat votes aye. Mr. Gomert.
Aye.
Mr. Gomert votes aye. Mr. Issa. Mr. Buck. Mr. Buck votes aye. Mr. Gates. Mr. Johnson of Louisiana. Mr. Biggs.
Aye.
Mr. Biggs votes aye. Mr. McClintock. Mr. McClintock votes aye. Mr. Stube. Mr. Tiffany.
Yes.
Mr. Stube votes yes. Mr. Tiffany.
Aye.
Mr. Tiffany votes aye. Mr. Massey.
Aye.
Mr. Massey votes aye. Mr. Roy.
Aye.
Mr. Roy votes aye. Mr. Bishop. Ms. Fishbach.
Aye.
Ms. Fishbach votes aye. Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz?
Yes.
Mr. Benz votes yes. Mr. Owens? Mr. Owens votes aye. Mr. Isa, you are not recorded. Mr. Isa votes aye. Mr. Bishop, you are not recorded. Mr. Bishop votes aye. Mr. Raskin, you are not recorded. Mr. Raskin votes no.
Are there any other members who have not been recorded who wish to be recorded? The clerk will report.
Mr. Chairman, there are 16 ayes and 20 noes.
The amendment is not agreed to. For what purpose does Mr. Massey seek recognition?
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Mr. Chairman, I reserve a point of order.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 3617, offered by Mr. Massey of Kentucky. Strike Section 2, strike Sections 4 through 9.
Without objection, the amendment is considered as read, and the gentleman is recognized in support of the amendment for 5 minutes.
I applaud the Democrats for doing something which is actually popular with the majority of the public, which is to decriminalize marijuana. But unfortunately, they've chosen to do it in a partisan way. My friend Dana Rohrabacher was always eager to reach across the aisle, and so is my friend Tulsi Gabbard. Mr. Blumenauer has been great at this. Former Congressman Polis was great at reaching across the aisle. In fact, we were able to get hemp legalized, and I want to show you how long that bill was. This is the entire text for the hemp amendment that went into the Farm Bill that legalized hemp. But the Democrats have taken today here, unfortunately, have taken something that's fairly simple, could be one page, turned it into an 89-page bill. My amendment strikes 75 of those pages. This bill, this is somewhat ridiculous. Yes, it removes certain marijuana crimes, but it creates new marijuana crimes. You realize on page 58 in this bill, unless my amendment is adopted, you could be convicted for 5 years and $10,000 for doing cannabis business without filing an application with the federal government. Do you realize you could serve 5 years or $10,000 for selling cannabis that's not had the tax paid on it? Do you realize you could receive 5 years and $10,000 in this bill in our committee right now for merely possessing marijuana that's not been taxed with the intent to redistribute it? And when I say 5 years and $10,000, I should say that's for each offense. People could spend the rest of their lives for violating the provisions of this bill, the MORE Act. They could spend the rest of their lives in prison. So are we going to have reparations for the people who spend their lives in prison because of this bill? I don't think we need to do this. I don't think we should do this. And so my amendment allows the bill to retain the decriminalization and the descheduling and the federal legalization of marijuana provisions in the bill. It allows the expungement provisions to stay in the bill. It simply strikes the tax and spend program which create new crimes, new marijuana crimes in the bill. This MORE Act came to the floor substantially just like the one we're looking at here today. When it came to the floor, it should have had a lot of Republican votes. You could say it was bipartisan because it had 5 Republican votes on the floor. But guess what? It had 6 Democrat noes. 6 moderate Democrats voted no on this bill. That shows you how partisan this bill is. 2 of those Democrats didn't return in a banner year for Democrat elections. And this bill shouldn't have to be something that's politically perilous. Look, it's hard for Republicans to vote for a bill that legalizes marijuana. I understand that. I polled this in my district. A majority of Republicans in my district do not support legalizing marijuana. But I also found out, though, that 75% of Republicans support getting the federal government out of this completely and letting states decide. So if you want a bill that is not politically perilous, if you want a bill that can reach across the aisle, if you want a bill that can pass the Senate, that they'll be motivated to bring up in the Senate, then please vote for my amendment, which leaves most of the bill intact. It merely strikes the taxing and the new crimes and the new subsidies that the program creates. You know, Ronald Reagan said government's view of the economy could be summed up in a few short phrases. If it moves, tax it. If it keeps moving, regulate it. And if it stops moving, subsidize it. This bill does all three of those things. And all we need to do is legalize a plant that God put on this planet that never should have been illegal. At the federal level, there's no constitutional justification or authorization for Congress to make this plant illegal. So I urge colleagues to vote for my amendment. Let's make this bill bipartisan. Let's make it a bill that every Democrat can vote for without losing their election. Let's make it a bill that most Republicans could vote for without losing their primary or their general. Let's work across the aisle and let's get a serious bill to the floor. Thank you, and I yield back.
Gentleman yields back. Does the gentleman insist on his point of order?
Yes, I do, Mr. Chairman. I insist on my point of order because this amendment addresses provisions in the bill that fall outside of the committee's jurisdiction and exceed the scope of the committee's referral, thereby violating Rule 10 and 12 of the House rules. As an example, Section 4 was referred to Ed and Labor, Section 5 to Ways and Means, Section 6 to Ways and Means, and Section 7 to the Small Business Committee, just as an example. And so, therefore, the amendment is not in order.
I agree, the amendment is not in order. Does anyone wish to be heard on the point of order?
It's, Mr. Chairman,
Yes.
just clarify, I think, doesn't the amendment just strike parts of the bill?
Parts of the bill that are not in our jurisdiction.
Then why are we
They were referred to the.
Why are we passing them in the first place?
Mr. Ranking Member, if you'll yield, I can maybe.
We can pass parts of the bill that aren't in our jurisdiction, but we can't take them out in an amendment that would actually simplify the bill and actually be a bill that might get bipartisan support. That's the stage we get to with Democrats in charge, I guess. I yield back.
The gentleman yields back.
May I speak on the point of order?
The gentleman is recognized on the point of order.
We were able to pass this hemp amendment without running it through judiciary and without running it through Energy and Commerce. It was actually an amendment that was allowed in the Rules Committee on the Ag Committee. So I'm confused as to why we couldn't just strike provisions of this bill. I don't seek to amend any of those provisions in this bill.
This isn't the Rules Committee.
Right, we don't have I understand that. You're the Rules Committee in this committee.
I'm not the Rules Committee.
I understand that the chairman and the majority get to rule whether this is in order or not.
The committees are given jurisdiction under the House rules, and we have to abide by that.
Okay. Here's what I request. And I realize that this would go to a vote, and I'm probably going to lose that vote. And in the interest of saving time, I won't demand a vote if the chairman has ruled me out of order, but I would just make a plea to my colleagues on the other side of the aisle who know that I support getting the federal government out of the prohibition of marijuana. I would just ask, in exchange for conceding this point of order, that the Democrats work to give us a more bipartisan
giveaway
bill.
Presentation, so we're gonna have a banner behind it. It's just
Members should mute.
Mr. Chairman?
For what purpose? Yes.
We're talking about the point of order, I thought.
Oh, yes, the amendment is out of order.
Mr. Chairman?
For what purpose does,
Just another
Mr. Jordan seek
clarification.
recognition?
When you offered the amendment in nature of a substitute that made changes to areas that weren't in our jurisdiction, somehow that's in order, but an amendment to strike parts of the bill is out of order?
Nature of the substitute, the only changes were in portions that were within our jurisdiction.
In your amendment, in the nature of a substitute, the only changes were in portions that were within our jurisdiction. The chair is prepared to rule the amendment is out of order. Does anyone, the amendment is out of order. Does anyone else seek recognition on this, on the amendment in the nature of a substitute? For what purpose does Mr. Bishop seek recognition?
Move to strike the last word.
Gentleman is recognized.
I'm sorry, Mr. Chairman, I actually have an amendment of the desk. That's what I sought recognition.
The clerk will report the amendment. Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 3617, offered by Mr. Bishop. Page 64, after line 19, insert the following.
Without objection, the amendment is considered as read. The gentleman is recognized in support of the amendment for 5 minutes.
I think that's not the one they just said. Okay, this is, I have two amendments. I just want to make sure I understood which one. I think, given the page reference, I know which one it is. It's on page 64, line 19. Isn't that the one we're talking about?
Yes.
Yes, thank you. So, following on Mr. Fitzgerald's ideas a little, Mr. Fitzgerald suggested that this bill extends too far the generosity of the grant-making provisions to include those who are traffickers, maybe major distributors of fentanyl and methamphetamine, opioids, but the committee rejected his amendment, said we ought to extend our latitude that far, our generosity that far. Mr. Fitzgerald offered another amendment that said we shouldn't let tax cheats get around the income limitations on grant recipients, and the committee saw fit to reject that too. So we ought to welcome the tax cheats into the grant program. And so what my amendment would do is suggest that the committee at least extend its generosity to one other group of people. If we can take care of the major drug distributors, if we can take care of the tax cheats, can we also have the generosity to provide that those who have declined to take the COVID-19 vaccine or have advocated in any way against maybe the COVID-19 vaccine mandate, that they can be included. So it would say those persons are eligible to be beneficiaries under the grant program. You know, it seems like these days that we want to absolve people of all sorts of responsibility. We've got sort of a generalized softening on crime, notwithstanding the fact that last year murders went up 30% in the United States in 1 year, biggest increase on record. But there's one area where we seem not to be able to extend that generosity, and that is to anybody who decides to show any kind of independence from the brutal rigidity of the vaccine mandate regime. We've seen this popping up in numbers of places across the country. We've seen countries across the world where the brutality extended to those who exercising judgment, perhaps poor judgment in some cases, but reasonable judgment, certainly reasoned judgment in some situations, not to accept a vaccine or to speak out with questions about the vaccine in various ways they're the ones that all the systems in the world appear to crack down on. Surely we don't want to let them, if we can let the people who are the major distributors of fentanyl into the United States be eligible for grants, and the guys who cheat on their taxes in order to come within an income limitation, let's also extend this opportunity to participate in grant programs to those who are objectors to the COVID-19 vaccine regime. And with that, I yield back.
The gentleman yields back. Does the gentleman insist on his point of order?
I don't, but I'd like the opportunity to respond to. I withdraw my point of order.
Point of order is withdrawn. I will recognize myself in opposition to the amendment. This amendment is like several of the previous amendments in that it seeks to condition the funds. I oppose the amendment. The funding provided under the grants in this bill are critical to addressing the harmful impact of the enforcement of marijuana laws, and I do not support conditioning these funds or limiting their application, which would only serve to undermine these critical restorative portions of the bill.
Will the chairman yield?
Therefore, I urge my colleagues to join me in opposing the amendment. I will yield to who?
Thank you, Mr. Chairman. I was just going to say, to your comment, I'm seeking to relieve people of a condition of receiving grants under the program, not to impose a new condition. And I yield back.
Gentleman yields back. I don't read it that way. I yield back. For what purpose does Mrs. Siciliani?
I move to strike the last word.
Gentleman is recognized.
I urge my colleagues to reject this amendment. The amendment proposes to relieve people of a condition of the amendment that doesn't exist. So you're not relieving them of a condition because that condition doesn't exist at all. But this is just the most recent example. I mean, this is so bizarre that the gentleman's amendment is an effort to continue to try to somehow protect people who are responsible for standing in the way for the one thing that will finally end this pandemic, vaccination. And the one thing that will endanger the lives of people with these breakthroughs because people aren't vaccinated. To go through the effort to draft an amendment to continue to protect people who are spreading misinformation or defying the directions of every public health official in an effort to somehow signal to their base, we're with you, it's okay, stand up, my body, my vaccine, except when it comes to reproductive health choices. I mean, this is insanity. We're never going to end this public health crisis until we end this pandemic. The only way out of this pandemic is vaccination. So rather than spending time drafting amendments, imagining someone's going to be denied a grant because of their advocacy, how about let's work together to advocate that everyone get vaccinated so we can once and for all get back to normal life in this country. And with that, I yield back.
Mr. Chairman?
Gentleman yields back. For what purpose does Mr.
Strike the
Jordan
last
seek
word.
recognition?
Strike the
Gentleman's
last word.
recognized.
Something that doesn't exist, tell that to the Border Patrol agents. They got till November 1st. If they don't get a vaccine, they're fired. That exists. Tell that to the healthcare workers who just got canned in New York. The heroes, you all called them heroes. We all called them heroes because they were a year ago. Tell that to them. Something that doesn't exist. That is the dumbest thing I've heard said today. Holy cow. Tell the Border Patrol agents who've been busting their tail for now month after month, record illegal crossings every single month. March was the highest month on record until April. April was the highest month on record until May. May was the highest month on record until June. June was the highest month on record until July. 212,000 illegal encounters in that month alone. Something that doesn't happen. They're going to lose their job if they don't do what Joe Biden says. And you say something that doesn't happen. Oh my goodness. You said this was a waste of our time. This is maybe the most important thing we can talk about, the freedoms that are being taken from the very people we represent, something that doesn't exist. You got to be kidding me. This is kind of stuff that just ticks me off because this is so basic. The Constitution, I mean, this is fundamental liberty we're talking about, people's livelihoods, and you give us a lecture on something that doesn't exist.
Will the gentleman yield then?
No, I will not. That is truly unbelievable. These Border Patrol agents, they know it exists. They know it exists. Oh, and here's the irony of that one. We just had a briefing from Mr. Mayorkas, Secretary Mayorkas. You know what he said? When the people who violate the law come across, they're offered a chance to take the vaccine. They get a choice. They get a choice, but not the guys who busted their tail, working hard, protecting us. All they get is attacked by you guys. If they happen to ride a horse, they get attacked by you guys. They don't get a choice. No, this exists. This is a darn good amendment from my friend and colleague from North Carolina. This definitely exists. It is a fundamental issue the country is dealing with as we speak. I yield the balance of my time to the sponsor of the amendment.
I thank the gentleman from Ohio. And boy, you couldn't make it any clearer, although you could give a lot more examples. In Charlotte, North Carolina, healthcare system fired 175 people for declining to take the vaccine. Many of them have had COVID and have superior immunization, superior immunity. Perhaps others should be taking the vaccine. I encourage people to take the vaccine. But I respect their liberty to decide. And what we see depicted in the response from the gentleman from Rhode Island is this imperious, brutal disregard, not at this time, imperious, brutal disregard for anyone who chooses to depart from orthodoxy. You can be a major distributor of the most damaging drugs on the planet. We'll extend our generosity to you. You can be a tax cheat who lies on your income tax returns about your income, illicitly produced income, in order to qualify for subsidies and grants. To you, we'll extend generosity. We want to be understanding to you. But the best we can say is, for all those people out there that think they might want to depart from the orthodoxy on the vaccine mandate, or speak about it in an online environment, send an email or a text, those people, we're going to pretend they don't even exist. And certainly, if vaccine things get applied to them, well, we're going to say it doesn't exist. It does exist, and it's happening everywhere. So what time would be better than to provide the appropriate exception and to bring those people within the confines of our generosity that this bill purports to extend? But you can see that that's not the thinking on the other side. Now, I yield back to the gentleman from Ohio.
The gentleman yields back. For what purpose does the gentlelady from Texas seek recognition?
Mr. Chairman, I strike the last word.
Gentlelady is recognized.
And I'll yield first to the gentleman from Rhode Island.
I just want to say very clearly, you know who doesn't have a choice, who doesn't get protected, is the more than 600,000 Americans who have died from this pandemic. And the advice of every single public health professional is that the only way we can prevent ongoing death in this country is vaccination. What I said doesn't exist is someone being denied a grant because they've advocated. That doesn't exist. That's made up. And this notion that you want to protect people online so they can spread misinformation. One of the greatest contributors to the cause of this pandemic is the fact that misinformation is being widely shared by conspiracy theorists. From everything that they're planning a chip in us to it's going to cause all these things. This has been tested by the FDA. It's safe. Every public health expert of any weight says the only way out of it is to get vaccinated. Countries like Iceland have had zero COVID deaths since April. Why? Everyone's vaccinated. This is not a mystery. And so this notion of what about the life, liberty of the 600,000 Americans who've died because of this pandemic and who continue to die because people won't get vaccinated? And with that, I yield back to the gentlelady with gratitude.
I thank the gentleman very much. As a proponent of the MORE Act, and as I initially started out on the basis of the importance of the MORE Act, let's get back to the MORE Act. And thank Mr. Bishop for his concerns that can be expressed in any arena that obviously continues to contribute to the high percentages of Americans who have died but who are dying. And I don't want to have the MORE Act that is constructively dealing with criminal justice reform, dealing with social justice programs, and responding to the overburden of incarceration on Black and brown communities, and in particular, African-American communities, seriously undermined because of an amendment that wants to endanger people, which is to suggest a free-for-all for those who are not vaccinated and to give a free-for-all for those who, as my colleague has said, is passing misinformation. I am stunned that we would have an amendment that suggests that we would discriminate against or otherwise disfavor an individual entity on the basis of COVID-19 vaccination. I hope when this bill is ultimately implemented that all Americans will be vaccinated unless there's an exception for religion or health matters, but to suggest that it is the norm to have people unvaccinated, so much so that we have to worry about them applying for a social justice grant and checking whether they're vaccinated, would be shameful and a disgrace to the world. Because the world looks to us to be constructive. The world is under-vaccinated. We have the ability to vaccinate all Americans, and I will not be a participant in any language that suggests it is a free-for-all to not be vaccinated and a free-for-all for giving misinformation that has caused people to die. For example, the CDC has recently come out to say that pregnant women are the most dangerous in terms of most dangerous condition for those who are not vaccinated, and that more pregnant women are dying who are not vaccinated. And there is a tendency for COVID-19 to be more deadly in pregnant women. But yet we can find social media encouraging pregnant women not to be vaccinated or frightening them, rather than allowing them to listen to their provider, their physician, about the health of them and their baby, their fetus. And so I'm not going to associate with something like this. It has no place in the discussion of the MORE Act. And anyone who wants to undermine the importance of vaccination, and I heard the gentleman say, oh, I support people being vaccinated, and I'm grateful that is on the record. But the amendment speaks clearly the complete opposite. No one is attempting to discriminate, but I can assure you, every time this federal government speaks, and thank you, President Biden, they must speak that we must get vaccinated. Because it is not an individual action, it is an action for the safety of the nation. There is still a national emergency. For those of us who wear our masks, it is a social disaster. And it has been contributed to unmasked persons and unvaccinated persons over and over again. Please support the underlying bill, which is the MORE legislation that reforms the criminal justice system and helps to move marijuana out of Schedule I, and I oppose the underlying amendment. I yield back.
The gentlelady yields back. For what purpose does Mr. McClintock seek recognition?
To speak on the measure.
The gentleman is recognized.
Mr. Chairman, study after study after study is now confirming that there is no statistical difference between the jurisdictions that required lockdowns, required mask mandates, closed schools, closed businesses, and those that did not. In fact, if you look at the mortality rates out of Sweden that never closed their schools, didn't force businesses to close, didn't mandate their population wear masks, certainly didn't place their populations under house arrest, their mortality rate from COVID is 500 per million or so.
The gentleman yield for a moment.
Less, no, I will not. Less than those in the United States. In fact, if the United States had Sweden's mortality numbers, there'd be 195,000 fewer dead Americans as a result. And Sweden, by the way, has an older population, which is at much higher risk of COVID. I got the vaccination gladly because, hey, it's one less thing to worry about. I'm 65 years old. I don't want to be laid up for 3 or 4 weeks. It was a decision that I think was a good one. But that's not going to be the decision that everybody is going to want to come to or should come to. It is definitely not the opinion of every health professional that every single person should get vaccinated. There's a study out of Israel that documents that males 20 to 24 have a higher chance of dying from myocarditis induced by the vaccine than dying from COVID. Those who've had the virus, according to another study out of Israel, have natural antibodies 27 times greater than the vaccine produces. For young people under 20, according to the CDC, the flu poses a greater mortality risk than COVID. Now those are the facts produced by the scientific research on this subject. And all of the demagoguery in the world is not going to change them. You know, I have found in my many years that politics tends to attract a much higher percentage of people who seem to think that they're so good at running their own lives that they're also entitled to run everybody else's. And I have found over the years, as I've gotten to know them, that they're no good at doing either. And I would suggest that maybe we ought to practice a little humility here and maybe recognize that each individual is different. Each individual has a right to decide for themselves what is in their best interest, and more likely than not, they're going to make good decisions. We have all made bad decisions in our lives from time to time. That is the price we pay for the freedom to make all the good decisions in our lives.
The gentleman yield.
And it would be nice if a free society and the government that is supposed to protect that freedom would occasionally practice that humility and recognize that.
Would the gentleman
Yes,
yield?
well, actually, Mr. Bishop first.
Just quickly, I'll say, I think, Mr. McClintock, what we're seeing instead, and the vociferous response to this proposed amendment, is that the Democrats don't view it with quite the humility that you would urge. They instead, they think they've been patient, they've been patient, but their patience is wearing thin. They want everybody to know that. And I yield back to the gentleman.
And I'll be happy to yield my time to the chair.
I thank the gentleman for yielding. A couple of things. Number one, Sweden conducted an experiment in that they thought that they should just use natural immunity to produce the antibodies without the vaccine. The result is they had a 3 times higher mortality rate than their neighboring Nordic countries, Norway, Denmark.
Reclaiming my time, sir, that's no longer true. I would suggest you go to Worldometer today. They track the daily numbers from every country in the world, and you will find that the mortality numbers from Sweden are now much lower than they are in the United States. And again, it's about 500 per million lower, or about 195,000 if you compare our population to theirs. And that's before you take into account they should have a much higher mortality rate, specifically because they have an older population by about 2 years.
Would the gentleman?
Yep.
Just make a simple fact. You take the vaccine not necessarily to protect you, but to protect everybody else, because you can't, or much less.
Reclaiming my time, that's precisely the point. I am protected because I have taken the vaccine. Those who have made a different choice pose no threat to me. That's exactly the point, Mr. Chairman. You've hit it on that nail on the head. And I thank you for doing so.
The gentleman's time is expired. For what purpose is Mr. Lusig recognition?
I move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I just want to talk a little bit about freedom. In the state of Ohio, you cannot send your child to public school if your child is not vaccinated against polio, diphtheria, tetanus, whooping cough, measles, mumps, rubella, chickenpox, and hepatitis B. And that's because the freedom of our kids in school depends on every kid being vaccinated against those contagious diseases. Your freedom ends when the thing you're carrying can kill me or my wife or my kids or your loved ones. That's why we have vaccines. It's this amazing inoculation that helps protect you against deadly and contagious diseases. And the problem is not only that this virus can kill people or make them so sick that they go to the hospital, it's that they end up taking up hospital beds so that every bed is now being filled with unvaccinated folks. And so when someone who is vaccinated and has a heart attack, their risk of death just increased because they can't go to a frickin' hospital because everything is full. So it does matter. And that's why the state of Ohio takes away people's choices in terms of vaccinations in order for their kids to go to school.
Gentleman yield?
So let's not
Will the gentleman yield?
come up with this newfound freedom on one particular FDA-approved vaccine that Donald Trump pushed for. Let's just be consistent here.
Well,
in society,
will the gentleman yield?
we protect people's health and safety. And let's talk about being humble. You cannot see this virus. You don't know if I have it. You don't know if you have it. And you don't know how this virus is going to interact with your body if you get infected with it.
Or actually do know.
Don't act like you do. Matthew chapter 4, verse 7 says, do not test the Lord your God. God created the laws of chemistry and biology. God is not going to make an exception just for you when it comes to this biological virus. Be humble, don't be arrogant, and talk to your doctor about vaccinations, because what most of Tom McClintock said is contradicted by multiple other studies. So don't trust me, don't trust McClintock, don't trust anyone on the Judiciary Committee. Go talk to a doctor. And if you don't have one, listen to doctors' organizations like the American Medical Association. Be humble, don't be arrogant. You cannot see this virus. Don't act like you can. I yield back.
Mr. Chairman.
The gentleman yields back. For what purpose does Mr. Roy seek recognition?
Johnson, strike the last word.
Johnson.
Mr. Roy had sought recognition first.
Oh, sorry.
Does Mr. Roy seek recognition?
I move to strike the last word. I'm happy to defer to Mr. Johnson to go first if he needs to, but otherwise I'll just go ahead and go.
Go ahead, Chip.
Okay. Move to strike the last word.
Gentleman is recognized.
Would the gentleman yield for a second? Would the gentleman yield?
Who is that asking?
Jim Jordan.
Yes, sir.
Well, I'm just responding to I thank gentleman for yielding. I just respond, if it's so bad and it's all about consistency, then why are people who come into this country illegally given the choice? And the agents who are protecting our very border aren't. I yield back.
Yeah, well, I appreciate the gentleman's point. I was going to make that point as well, given what we're dealing with in very real time in the state of Texas. I noticed that the vociferous opposition by my colleagues on the other side of the aisle from this amendment tells you everything you need to know about the extent to which the other side of the aisle wants to say you will comply. And the gentleman from California made that fairly clear, notably getting out a little gospel to try to preach. I'm also pretty sure that the good Lord didn't create this vaccine. I think this vaccine was created in a lab in Wuhan. Also probably with a significant amount of federal dollars funding it out of the United States. But that's a whole nother conversation. And we should have a hearing on all of that. I think the American people would like to know precisely how this virus was created, who was involved with it, and who knew what when, including Dr. Fauci, which my colleagues on the other side of the aisle have no problem just worshiping the ground that he walks on, despite inconsistencies nonstop over the last 2 years. The one consistency in the response for this country to the virus. I would also note that when my colleagues on the other side of the aisle preach to us about vaccines and mandates, first of all, any mandates that currently exist with respect to vaccines are properly at the state and local level, where police powers are actually prevalent, not where they are unconstitutionally and unlawfully being tried to be applied by the President of the United States. President Biden has no authority, none, zero, to do what he said he was doing 2 weeks ago in mandating that businesses with 100 or more employees go out and must force their employees to get vaccinated. And meanwhile, further, my dad, who suffered from polio, and I know we've got a member of this committee who suffered from polio, I know full well, if you go back and look at it, the rollout of the Salk vaccine, that it was after many years of working on it and a whole lot of trial, we saw that it was rolled out at a much slower rate even than what we've done today. We now have 77% of adult Americans who have been vaccinated with at least one shot. 7%, give or take, check the recent data, of 2 shots. We've been rolling it out in hundreds, certainly millions, of over 200 million Americans who have gotten a shot. And the fact is, we have massive amounts of natural immunity. And doctors, very, very strong doctors with strong reputation, have been talking about the importance of natural immunity and talking about how it's been ignored. For example, Dr. Macri from Johns Hopkins, who talks about this on a regular basis, how natural immunity is being ignored. And the federal government and my colleagues on the other side of the aisle want to ignore that and then force individuals to say, oh, you must go get vaccinated in order to take part in society, with 8 months of data of vaccinated Americans. Oh, by the way, note that in countries, for example, Norway advises spacing out the doses of the vaccines for kids 16 to 17, anywhere from 8 to 12 weeks. Why? To minimize the known and growing risk of myocarditis. This is a real thing, and people are really looking at it. And yet my colleagues on the other side of the aisle believe that it is in their infinite wisdom to go around and tell 330 million Americans what they must do. Let me be perfectly clear. I am never going to tell you or anyone else whether or not I have been vaccinated. I am not going to listen to any rule you put forward about whether I must get my children vaccinated. That is a non-starter in this free country. And freedom in this country means I decide what's in the best interest of my family. I decide what's in the best interest of my health. That's what healthcare freedom actually means. And I'm also going to stand up against an administration that is blocking actual treatments for people, for example, in Texas, getting in the way of monoclonal antibody treatments, cutting those in half, harming citizens directly because of politicized decisions by an administration that wants to kowtow to those who want to tell us to go get a vaccine that the same people in that administration were just last year saying we shouldn't do because President Trump was working to get that vaccine out. We should all be for science. We should all be for vaccines where they help people. We should all be for making sure that people know truth, but we should not be in the business of having the federal government mandate that Americans have to go comply with whatever their rulings are. I will support this amendment and any other amendment to minimize the strength and power of this government to interfere with Americans' health care. I yield back.
The gentleman yields back. For what purpose does Mr. Raskin seek recognition?
I move to strike the last word.
Without objection, the gentleman is recognized.
Thank you, Mr. Chairman. I entered the room to hear a series of speeches from colleagues saying that we should be exercising more modesty and humility in controlling other Americans' healthcare decisions. And I just got back from a hearing right next door in the Oversight Committee about the attack on abortion rights and Roe versus Wade and the new Texas law, which compels women and girls to have an abortion after 6 weeks if they've been raped or they're the victim of incest. It's a position so extreme and so outrageous, even one of the Republican witnesses said she didn't agree with that. I wonder if there are any Republican colleagues here who, in an outburst of humility and modesty, would say that they oppose the Texas law, which says that any American can go ahead and sue a doctor, a nurse, a healthcare provider, a mother or father for helping a 17-year-old girl get an abortion after she's been victimized in a gang rape. Is there anybody who will say that they're opposed to that Texas law?
Will the gentleman yield?
By all means, for that purpose and that purpose only, I will.
I'm opposed to two provisions of it. One, that allow individuals to sue others to enforce the law. I think that is a terrible trend.
And you think it's unconstitutional?
And I do.
Okay.
And in fact, I think we ought to get out of the business of using the civil courts to punish people. That's why we have criminal courts.
Okay, make your other point, please, because I've got other stuff to say.
The other point is, I think the standard ought to be what we as a society have formed a consensus around, and that is if you have a brainwave and a heartbeat, you're alive and have that inherent protection.
Reclaiming my time, thank you. Are there any other Republican members who will rise in an exercise of humility and modesty to oppose the Texas law, which allows anybody in the country, a rapist, a murderer, to sue people who help a woman or a girl get an abortion in the case of a rape? Well, thank you for your courage in standing up. That's point number one. Point number two, my distinguished colleague from Texas invoked Wuhan and his interest in the source of COVID-19. I'm very interested in that too. I'm also very interested in why Donald Trump defended President Xi 19 different times in January, February, March, and April when he was asked the question about what he was doing to try to get China to disclose details of what was taking place. But he wrapped himself around the Chinese Communist Party and the Chinese government and said everything was fine. He had a great relationship with them. Everything was excellent. Everything was going fine. The gentleman yield? I'd like to, I don't have time now, but if I have time at the end, I will. I thought you wanted to interact. Number three, GOP attacks on mask requirements and COVID-19 vaccines are killing people in red states. In study after study now, you can see there's a direct correlation between how much of a population is vaccinated and then how much of a population actually gets COVID-19 and ends up in the hospital. And I'd be very happy to have a whole separate hearing about this. But in the states where there are higher vaccination rates, there are much lower incidences of infection and then hospitalization and then death. And in the places where propaganda and disinformation are running amok, people are getting the disease more, they're ending up in the hospital more, and they're dying. And that's just a fact. Of 54,000 people who've died since June in the latest wave of COVID-19, nearly 1 in 5 have died in Florida. So a state with 6% of the whole population is now responsible for 18% of the nation's COVID-19 deaths because of the policies of the governor who engages in this kind of rhetoric. This is very serious business. Why aren't we telling the people the truth? If you want to be safe from COVID-19, get the vaccine and wear a mask when you're not speaking directly in public. And you know, it shocks me that we have members of Congress now who are getting the vaccine themselves but are helping to circulate continuing myths and lies that are killing people in the country. I yield back to you, Mr. Chairman.
The gentleman yields back. For what purpose does Mr. Johnson seek recognition?
Strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I'll be brief. I just was compelled to speak up. A few moments ago, Mr. Liu was, I would say, disparaging people of faith. I mean, let me tell you what the people back home hear when they hear comments. My friend Mr. Raskin, the things he just said, when they hear comments from people like Mr. Liu, they hear that they're being marginalized, they're being mocked in some cases because they live in a certain region of the country or they have a sincerely held religious belief. They're sick of that. They don't believe that they're respected. You know, one of the things that we used to respect, and all of us used to try to defend in this country, I will not yield. One of the things we used to respect is the fundamental freedom, the right of conscience. Mr. Liu had the audacity to cite the 4th chapter of Matthew and suggest that somehow you're putting the Lord your God to the test if you have a problem injecting into your veins a vaccine that was created in record time, that did not go through the average 5-year trial, first animal trials, then human trials, and all the rest, in order to be fully approved. Look, some people have a sincerely held religious belief about the origins of the vaccine. Whether or not it was derived by the use of fetal tissue, cells that came from fetal tissues and all the rest, from aborted children many years ago. Look, you can mock that, you can dispute it, but if people have a sincerely held religious belief in this country, we have always respected that, even with regard to exemptions from vaccines. But we're in an era now where that's no longer tolerated. We're big government advocates, big government socialists, people in the Congress, the greatest deliberative body in the world, would trample upon those fundamental rights in order to achieve an objective with some big spending program they have, or to, some of them in good faith, trying to protect the public health. We have these inalienable rights. We have these fundamental rights that we too easily overlook today. It concerns us. It concerns many of us on this side of the aisle. It concerns a lot of people back home. And I would just say respectfully, if you're going to bring religion into it, at least don't take Scripture out of context. At least respect people with an opposing view, because at the end of the day, that's the beauty of America. We may have very different philosophies, very different principles, things that we believe in, but we respect one another's rights to disagree. And if we lose that, we lose something very important, very essential, very precious, that makes us Americans. Even more fundamentally than that, that makes us fellow human beings. So I would just say, let's everybody dial the rhetoric back. Let's respect one another. I support the amendment. I associate myself with the comments of Mr. Roy a few moments ago and our ranking member, Mr. Jordan. And I would just say, let's get back to the business of legislating and don't pass judgment on your neighbors, on your fellow Americans, just because they have a different view in good faith on a very contentious issue of public policy. With that, I yield back.
Will the gentleman yield?
I'll yield, yes.
Thank you. I just want to update the numbers. I just looked them up today. Sweden's death per million from COVID since this outbreak began, or this pandemic began, 1,456. United States, 2,142 per million, which means that Sweden has 686 per million fewer deaths from COVID than the United States. To the gentleman's point that there's a variation between the states. It's true, Florida has a mortality rate right now of 2,518 per million. New York, on the other hand, has a mortality rate of 2,873. Florida has 355 per million fewer deaths from COVID than New York. Look at Colorado and Utah side by side. Colorado's been very strict, Utah has not. Utah's death rate is at 911 per million. Colorado at 1,363. They share a common border. They have the same kind of demography, the same kind of geography, the same climate. Utah, which was much less willing to shut down its state, force people to wear masks, and all the other things we've seen from the lockdown left. Utah has 452 deaths per million fewer than that in Colorado right next door. Those are the numbers. Make of them what you will.
I thank the gentleman from Mr. McClintock. It's good when facts back up common sense. I yield to Mr. Gates.
I thank the gentleman for yielding. Mr. Chairman, I seek unanimous consent to enter into the record an ABC News report from Central Florida entitled COVID-19 Cases Declining in Florida as Immunity Increases. And in that piece, it notes that the infection rate in Florida is now 30th in the country. So Florida man does not abide these lockdowns and restrictions in liberty and freedom. And when I travel the country, as I do with some regularity, people wish they were Florida. And we don't plan on changing. I thank the gentleman for yielding.
Without objection, and the gentleman's time has expired.
Mr.
There are no further speakers.
Mr. Chairman,
The question,
Mrs. Massey,
for what purpose does Mr. Massey seek recognition?
I move to strike the last word.
Gentleman is recognized.
I support the amendment, and I just want to point out that there's a
Mr.
blind
Chairman, I'm
spot.
having difficulty hearing
Yeah,
him.
me too.
Is this better?
Yes.
Much better, thank you.
Thank you. I had to clip my microphone on. Thank you. I'm sorry. I support the amendment. And I just want to say there's a blind spot here where people are denying science. They're denying the science of natural immunity as a result of a previous infection. And the zealous cult-like pursuit of the people who want everyone vaccinated, including those who have natural immunity, is causing vaccine hesitancy. I mean, even George Washington, General George Washington, who had his troops vaccinated for smallpox, recognized natural immunity. He didn't pursue, he said to vaccinate all of them who hadn't had smallpox. How did he know natural immunity worked? General George Washington had smallpox as a teenager. He didn't need the vaccine and he knew it. And so, when you look at the Pfizer trial data, let's just take the drug companies' data. They don't claim that this helps you if you've already had the virus, that the vaccine helps you. In fact, their first study, which had tens of thousands of people, showed no benefit to those who already had natural immunity as a result of a prior infection. The Moderna trials showed the same thing. We've got trials from Cleveland Clinic or studies from Cleveland Clinic of the 50,000 people there that showed the same thing. And most recently, the data out of Israel in a study has showed that you're 27 times less likely to contract symptomatic COVID. By the way, that was the endpoint in the Pfizer trial. Did you get symptomatic COVID? You're 27 times less likely to contract symptomatic COVID if you've already had the virus as compared to those who are vaccinated and who haven't already had the virus. You're 8 times less likely to end up in the hospital if you have natural immunity acquired from a previous infection, as opposed to those who've been vaccinated and not had the infection. So the mandates that have been pushed, in fact, the mandate in the military, as far as we know, the mandate that Joe Biden is going to push through OSHA, the mandate that's been promulgated on federal employees, none of those recognize what we've known for 250 years is the case with most viruses, and what we've shown empirically is the case with this virus. That natural immunity from a previous infection is superior to the vaccine, to any vaccine that we've got for this virus. It doesn't matter which brand, we see the same results over and over.
Would the gentleman yield?
I would yield to Ms. Jackson Lee.
I have always respected my good friend, and I still do. Congressman Massey, you are a scientist and inventor. We are discussing the MORE Act. I'll just very briefly say, because you yielded to me, in that what your theory is that let us go ahead and get sick. Some will make it, and some will die. And you realize that. I mean, we may be different in our opinions, but it is not the preferable approach to dealing with infectious diseases to say it is give a free-for-all, get sick, get the antibodies. if you make it. My
I think-
Lieutenant Governor, Congressman, just this
May I
last sentence.
May I respond to that? Let me
That-
reclaim my time.
Lieutenant Governor, I'll yield
Let
back.
me reclaim my time and
Go right
and-
ahead.
and
I'll talk
respond to
about him
that.
later, but thank you so very much for yielding. Thank you, sir.
Well, thank you for bringing up that point. And Ms. Jackson Lee is correct. I should have been clear that I am not encouraging anybody who's not had the virus to seek to get the virus. That is not a good strategy. I am not encouraging that. If you're at risk, the vaccine is likely to reduce your symptoms. When you eventually do get COVID, which you probably will, even if
The
you're
gentleman
vaccinated.
yield.
Not yet. I need to address Ms. Jackson Lee's very important point, which is, do not see, this is when all I'm doing is pointing out those who have been unfortunate enough, which is probably at least half the population of the United States. The CDC, the last time they estimated it was 100 million people. I am only speaking to those people and not to the people who are seeking to escape this virus or escape the
Gentleman now yield.
symptoms of this virus. And my time has expired, Mr. Chairman. I yield back.
Gentleman yields back. For what purpose does Ms. Dean seek recognition?
I move to strike the last word, Mr. Chairman.
The gentlelady is recognized.
I rise in opposition to the amendment and in support of the MORE Act. For those who might be listening in from the outside, yes, we are actually here talking about the MORE Act. You wouldn't know it from the last couple of hours of propaganda that is coming from many members of this dais. What I would want to say is, Mr. Chairman, maybe if our esteemed colleagues on the other side of the aisle are really interested in talking more about vaccination and the cost, the toll that COVID has taken on our country, maybe we could take a field hearing to what has been called this morning 20 acres of goodbyes. I commend this art installation to every one of you. It will take your breath away. I visited there this week and planted a flag on behalf of my mother-in-law who died of COVID. But it's not just my mother-in-law. It's 700,000 souls in this country who have died of COVID. And sadly now that we have a vaccine, so many of those who are dying are the unvaccinated because of bad information. We are responsible to tell the truth. We are responsible to protect the health and safety of others. At this moment, 2,000 people a day are dying of COVID. In a country that has the blessings of vaccine, in a world that has the blessings of vaccine. I buried a friend just 2 weeks ago who died of breakthrough COVID after being vaccinated because sadly he had had chemotherapy.
Would the gentlelady yield?
Not yet. So for those who talk about the zealous cult-like response, I think the words are actually in mirror image. We have 20 acres of goodbyes. Sadly, that will grow to 21 acres of goodbyes if we don't stop the disinformation. In the meantime, I am in great support of the MORE Act. I thank those who have brought that forward yet again this Congress, and I yield to Mr. Liu.
Thank you, Representative Dean. Just briefly, I think I agree we should try to take down the temperature. I'm fine with that. And if my colleagues across the aisle think that we shouldn't be citing scripture, then I would especially suggest that maybe Republican elected officials should also stop citing scripture. And by the way, I know that the Pope has said that getting vaccinated is an act of love. But what I really want to say is, look, I think we're equipped to debate issues of freedom, of law, and so on. But please stop spreading disinformation on the medical side. And for anyone watching, don't come to a member of Congress about medical advice, because for every study that the Republicans put out, I can show you another study that contradicts them. Forbes recently put out an article saying that 36% of people who had COVID got no antibodies, so they weren't protected. And that's why another article recently came out saying there's been a 300% spike in reinfections of people who had COVID. So the one thing I want people to know is don't listen to us on medical advice. Go talk to your doctor. And if you don't have a doctor, please read what the American Medical Association has said about vaccines. Don't listen to what politicians say when they cite studies. Please go talk to your doctor. They will give you the best medical advice on vaccines, on natural immunity, because it varies greatly among individuals.
Will the
And with that,
gentlelady?
I'll yield back to I think it's Representative Dean's time, so you're back
The
here.
gentlelady yields.
And I yield to the chair. Thank you.
I thank the gentlelady. I want to say I agree with everything that the gentlelady has said, that Mr. Lewis said, that everybody on the Democratic side of the aisle has said about the necessity for vaccination and the validity of the government promoting it. I just want to say one thing. What is any of this got to do with the MORE Act? We're talking about a marijuana bill. We're not talking about COVID-19. Why are we spending all this time on, we disagree on COVID-19, obviously, but why are we spending all this time on it, on a marijuana bill? I yield back.
Not at it? Do you want a shot? And Mr. Chairman, thank you very much. I agree, and I yield back.
The gentlelady yields back. For what purpose does Mr. Fitzgerald seek recognition?
Well, Mr. Chairman, I've been ratted out twice while sitting here that I didn't have my mask on. If you don't think that this is about power and control, especially within this building, then you're naive. My wife and I went to a football game at Soldier Field last Saturday in the city of Chicago. Soldier Field was packed to the gills. No one was wearing a mask. How many people in this room went to the baseball game last night? What was the crowd? 25,000? Nobody was wearing a mask. I mean, I'm not going to say there weren't a few people wearing a mask. I'm just saying. I mean, but when you come here, you make a mockery. You make a mockery of science and public health. That's why the next time there is another pandemic, all of these public health officials across this nation, I don't care if it's municipal or state or whatever it might be, people are going to say, forget it. I already lived through this. It's a joke.
Would the gentleman yield?
I yield, Mr. Chair.
Again, this is all very interesting, but what has this got to do with the marijuana bill?
Well, somebody in this room just ratted me out twice to say, put your mask back on. I mean, it's happening right here in this room right now. You get dirty looks all the time if you don't have your mask on. So, I mean, it's not just about, by the way, the amendment we're talking about, but it's about what's going on in this hearing room.
The gentleman yields back. If there are no other speakers, the question occurs on the amendment. All in favor say aye. Opposed, no.
Aye.
No. No. In the opinion of the chair, the noes have it.
Request a roll call vote.
Roll call vote is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson-Lee?
Give you a second.
Ms. Jackson-Lee votes no. Mr. Cohen? Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass? Mr. Jeffries? Mr. Cicilline?
No.
Mr. Cicilline votes no. Mr. Swalwell? Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal?
No.
Someone has to mute their line.
No. Jayapal votes no.
Ms. Jayapal votes no. Ms. Stemmings?
No.
Ms. Stemmings votes no. Mr. Correa?
No.
Mr. Correa votes no. Ms. Scanlon? Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath?
No.
Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
No.
Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush? Mr. Jordan? Yes. Mr. Jordan votes yes. Mr. Shabbat?
Aye.
Mr. Shabbat votes aye. Mr. Gomert? Mr. Isa?
Yes.
Mr. Isa votes yes. Mr. Buck? Mr. Gates? Mr. Gates votes yes. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Stubbe?
Whatever. Yes. Hold on.
Mr. Stubbe votes yes. Mr. Tiffany?
Aye.
Mr. Tiffany votes aye. Mr. Massey?
Aye.
Mr. Massey votes aye. Mr. Roy?
Aye.
Mr. Roy votes aye. Mr. Bishop?
Aye.
Mr. Bishop votes aye. Ms. Fishbach?
Aye.
Ms. Fishbach votes aye. Ms. Sparts?
Yes.
Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz? Mr. Benz votes yes. Mr. Owens? Mr. Owens votes aye.
This is Mr. Cohen. I'd like to vote no.
Mr. Cohen votes no. Mr. Biggs, you are not recorded. Mr. Biggs votes yes.
Hi, this is Scanlon. Am I recorded?
Ms. Scanlon, you are not recorded.
Scanlon votes nay.
Ms. Scanlon votes nay.
This is Gomert. Gomert votes aye.
Mr. Gomert votes aye. Any other members who have not voted who wish to be recorded? Ms. Lockford? Are there any other members? If not, the clerk will report. Madam Chair, there are 18 ayes and 20 noes. The amendment is not agreed to.
Excuse me, how am I recorded?
Ms. Bass? Ms. Bass, you are not recorded.
Hear them. Oh, that's what they- Oh. Hello? How am I recorded?
Ms. Bass, you are not recorded.
Oh, Bass votes no.
Ms. Bass votes no. The amendment is not agreed to. For what purpose does Mr. Bishop seek recognition?
I have an amendment at the desk.
Point of order has been reserved. The clerk will report the amendment. Amendment to the amendment in the nature of a substitute to H.R. 3617, offered by Mr. Bishop of North Carolina. Page 89, insert after line 17. Without objection, the amendment is considered as read, and the gentleman is recognized in support of the amendment.
I thank the chairman. And as others have made the point, although the last argument certainly went far afield from a minor amendment to the MORE Act, the MORE Act is about marijuana legalization across the country. And as I've suggested, I think there are considerable negative implications, and unfortunately, they're often ignored. One of the biggest is what's called drugged driving. In Washington State, in Washington State, fatal crash drivers testing positive for THC is more than double. In Vermont, since 2010, of course, these are states where legalization is occurring. In Vermont, since 2010, fatal crashes linked to marijuana use have risen by 173%. In Oregon, 47% who died in a car crash in 2018 tested positive for marijuana. More Indiana drivers in deadly car crashes test positive for drugs than for alcohol. In Colorado, the center of this movement, since recreational marijuana was legalized, marijuana-related traffic deaths increased 151%, while all Colorado traffic deaths increased 35%. Since recreational marijuana was legalized, traffic deaths involving drivers who tested positive for marijuana more than doubled, from 55 in 2013 to 138 people killed in 2017. This equates to one person killed every 2.5 days compared to one person killed every 6.5 days. As a North Carolina sheriff put it, marijuana intoxication on our highways is a killer. So governments liberalizing marijuana laws are predictably seeing people die. But here is another disparity. Since we've been talking about disparities some during the course of this debate, law enforcement tell us that they lack a reliable roadside test to detect marijuana use or a uniform standard to measure marijuana toxicity. And yet this bill proceeds without addressing that issue. My amendment would require that the Department of Transportation develop best practices for the recognition and testing of drivers impaired by marijuana no later than 180 days after the date of enactment. Further, it would require that DOT publish these best practices prior to this act taking effect. This would ensure that local authorities can protect their communities from impaired drivers after the inevitable increase in marijuana usage this bill will facilitate. And with that, I yield back.
Madam Chair?
Ms. Jackson Lee, do you insist on your point of order?
I do insist on my point of order. While empathetic to the gentleman, the amendment addresses provisions in the bill that fall outside of the committee's jurisdiction and exceeds the scope of the committee's referral. This amendment in particular addresses a matter of transportation that is not within the committee's jurisdiction and thereby violating Rules 10 and 12 of House Rules.
Wish to be heard?
Does the gentleman wish to be heard?
I do.
You are recognized.
Thank you, ma'am. That technical ruling I anticipate might be sustained, but I will say that's exactly, it depicts the problem very much, which is there is a recklessness in moving forward with legislation like this without a careful, methodical, and wise assessment and treatment of the corollary effects that it will have. In fact, it's difficult for me to imagine that you can move forward with what is in our jurisdiction without your sense of that policy and the wisdom of that policy reflecting the substance of what I've offered as an amendment. How you can divide the two is beyond me. And I think that should result in a ruling that it is within our jurisdiction. But I can understand the technical point. Now yield back.
The chair is prepared to rule. The gentleman seeks to amend materials in this bill that is subject to the jurisdiction of another committee. It therefore violates House rules and is not in order. The jurisdiction is clearly, as the gentlewoman says, in another committee having to deal with the Department of Transportation. And of course, driving under the influence is within the criminal codes of individual states. Therefore, the House rule, the amendment is not in order. Are there any further amendments to the amendment in nature of a substitute? If not, the question occurs on the amendment in the nature of a substitute. This will be followed immediately by a vote on final passage of the bill. All those in favor respond by saying aye. Aye. Those opposed, no. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is agreed to. A reporting quorum being present, the question is on the motion to report the bill, H.R. 3617, as amended favorably to the House. Those in favor respond by saying aye.
Aye.
Those opposed, no. The ayes have it, and the bill is ordered reported favorably.
Request the yeas and nays.
Yeas and nays are being requested, Jamie.
A recorded vote has been requested, and the clerk will call the roll.
Mr. Nadler. Aye. Mr. Nadler votes aye. Ms. Lofgren.
Aye.
Ms. Lofgren votes aye. Ms. Jackson Lee.
Aye.
Ms. Jackson Lee votes aye. Mr. Cohen.
Aye.
Mr. Cohen votes aye. Mr. Johnson of Georgia.
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch. Ms. Bass.
Aye.
Mr. Jeffries.
No, I'm recording right now. No.
Mr. Cicilline.
I vote aye, and Mr. Deutsch is here as well.
Mr. Deutsch.
Aye.
Mr. Deutsch votes aye. Mr. Swalwell.
Aye.
Mr. Swalwell votes aye. Mr. Liu.
Aye.
Mr. Liu votes aye.
Well,
Mr. Raskin.
I mean, don't,
Aye.
from what we see
Mr.
now,
Raskin votes aye.
I mean, don't you
Ms.
think it's
Jayapal.
ratcheted up so high that
Aye. Will members please mute?
some of the Republicans are,
Ms. Jayapal
gotta
votes
be-
aye.
we gotta do something about
Ms.
that.
Stimmings.
Mute. Someone needs to mute.
Ms. Stimmings votes aye.
Madam Chair, I'm having difficulty with the
Yeah.
noise. Somebody needs to.
As we
mute.
are, would please members mute unless you are called upon?
Madam Chairman, I think it's Mr. Tiffany.
Mr. Correa.
Aye.
Mr. Correa votes aye.
Representative Tiffany, perhaps you could mute.
Ms. Scanlon.
Aye.
Ms. Scanlon votes aye. Ms. Garcia.
Aye.
Ms. Garcia votes aye. Mr. Neguse.
Aye.
Mr. Neguse votes aye. Ms. McBath.
Aye.
Ms. McBath votes aye. Mr. Stanton.
Aye.
Mr. Stanton votes aye. Ms. Dean.
Aye.
Ms. Dean votes aye. Ms. Escobar.
Aye.
Ms. Escobar votes aye. Mr. Jones. Ms. Ross.
Ross votes aye.
Ms. Ross votes aye. Ms. Bush. Mr. Jordan. Mr. Jordan votes no. Mr. Shabbat.
No.
Mr. Shabbat votes no. Mr. Gomert.
Gomer votes no.
Mr. Gomert votes no. Mr. Issa.
No.
Mr. Issa votes no. Mr. Buck. Mr. Gates.
Aye.
Mr. Gates votes aye. Mr. Johnson of Louisiana. Mr. Johnson of Louisiana votes no. Mr. Biggs.
No.
Mr. Biggs votes no. Mr. McClintock.
Aye.
Mr. McClintock votes aye. Mr. Stube. Mr. Tiffany.
Aye.
Mr. Tiffany votes aye. Mr. Massey.
No.
Mr. Massey votes no. Mr. Roy.
No.
Mr. Roy votes no. Mr. Bishop. Mr. Bishop votes no. Ms. Fishbach.
No.
Ms. Fishbach votes no. Ms. Sparts.
No.
Ms. Sparts votes no. Mr. Fitzgerald. Mr. Fitzgerald votes no. Mr. Benz. Mr. Benz votes no. Mr. Owens.
No.
Mr. Owens votes no. Mr. Biggs, you recorded as no.
How am I recorded? Bass?
Ms. Bass, you are not recorded.
Aye.
Ms. Bass votes aye.
Mr. Chairman, how am I recorded?
Mr. Jones, you are not recorded.
Aye.
Mr. Jones votes aye.
Madam Chairman, how am I, or Mr. Chairman, how am I recorded?
Mr. Tiffany, you're recorded as aye.
I would like to be recorded as no.
Mr. Tiffany votes no.
Chairman, how am I recorded?
Mr. Jeffries, you are not recorded.
Mr. Jeffries votes aye.
Mr. Jeffries votes aye.
Are there any other members who haven't been recorded who wish to be recorded? Clerk will report.
Mr. Chairman, there are 26 ayes and 15 noes.
The ayes have it, and the bill is amended, is ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 2116, the Creating a Respectful and Open World for Natural Hair Act of 2021, or the Crown Act of 2021, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2116, to prohibit discrimination based on an individual's texture or style of hair.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 2116, the Creating a Respectful and Open World for Natural Hair Act of 2021, or the Crown Act, explicitly prohibits discrimination on the basis of hair texture or hairstyles commonly associated with a particular race or national origin in areas of the law where discrimination on the basis of race or national origin is already prohibited. To be clear, it is my view that existing civil rights statutes already make such kind of hair-based discrimination unlawful. The Equal Employment Opportunity Commission agrees, having issued guidance interpreting Title VII of the Civil Rights Act of 1964 to prohibit such discrimination as a form of race discrimination in certain circumstances. Unfortunately, several federal courts have erroneously rejected this interpretation, which is why the Crown Act is urgently needed. This legislation will leave no ambiguity that in key areas in which federal law prohibits race and national origin discrimination, such as employment, housing, and public accommodations, discrimination based on an individual's hair texture or hairstyle, if they are commonly associated with a particular race or national origin, is unlawful. The history of discrimination in this country is unfortunately older than the country itself, and we are still living with the consequences today. Congress took a pivotal step in the fight against racism and discrimination when it passed the Civil Rights Act of 1964, prohibiting discrimination on the basis of race and national origin, as well as other characteristics in key areas of life. This law did not eliminate discrimination entirely. One cannot legislate away hate, but it provided critical recourse for those who face discrimination, and it made clear that the government has a compelling interest in protecting against discrimination. While racism and discrimination sometimes appear in overt forms, they can also manifest themselves in more subtle ways. One way is discrimination based on natural hairstyles and hair textures associated with people of African descent. Often these hairstyles are protective, such as tucking the ends of one's hair away to minimize manipulation and exposure to the weather. And they can play an important role in helping keeping one's hair healthy. But according to a 2019 study of Black and non-Black women conducted by the Joy Collective, Black people are, quote, disproportionately burdened by policies and practices in public places, including the workplace, that target, profile, or single them out for natural hairstyles, unquote, and other hairstyles traditionally associated with their race, like braids, locks, and twists. Among the study's other findings are that 80% of Black women believe that they had to change their hair from its natural state to fit in at the office, and that they were 83% more likely to be judged harshly because of their looks. While this study illustrates the prevalence of hair discrimination, Numerous stories across the country put names and faces to the people behind those numbers. For example, a Texas student was told that he would not be allowed to walk at graduation because his dreadlocks were too long. A Florida boy was turned away from his first day of school because his hair was too long, and the New Orleans area girl was sent home for wearing braids. Unfortunately, these incidents are not restricted just to schools. There have been numerous reports of Black employees being told to change their hair because it violated their company's dress code, or being denied employment in the first place because of their hairstyles. In view of these disturbing facts, in California, in 2019, California enacted legislation extending certain anti-discrimination statutes to prohibit discrimination on the basis of an individual's natural hairstyle. Since then, 13 other states have enacted similar laws, in every case with bipartisan support, and sometimes even with the unanimous support of both parties. While I applaud these states for taking action, this is a matter of basic justice that demands a national solution by Congress. That is why I support the Crown Act. This legislation passed the committee and the House by voice vote last year, and I hope that we will do so again this year. I thank the gentlewoman from New Jersey, Representative Bonnie Watson-Coleman, for introducing and championing this important bill in Congress. I support this legislation, and I urge the committee to report it favorably to the House. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, we all agree that racial discrimination is wrong, and blaming hairstyle or anything else does not change that. But racial discrimination is already illegal under federal law, and finding excuses, whatever they may be, is already inconsistent with our federal civil rights laws. The Supreme Court settled this issue in 1973. The court held that using a pretextual reason as cover for undertaking an action prohibited by federal civil rights laws is still a violation of federal civil rights law. As early as 1976, federal courts held that discrimination on the basis of hairstyle associated with a certain race or national origin may constitute racial discrimination. If a person's hairstyle or hair texture is associated with the person's race or natural origin and used as a pretext for discrimination, that conduct is already prohibited by state and federal law. Schools, employers, and other entities covered by federal civil rights laws may have race-neutral policies that everyone must follow. This is particularly true when the policy is necessary for a critical function of the job. For instance, ensuring that personal protective equipment fits properly and protects the wearer. A diver cannot adequately perform their duties if they have hair that prevents them from properly wearing a respirator. A soldier cannot have hair that prevents them from wearing a helmet. But I don't believe that is what we're talking about today. What we are talking about today is the use of hairstyle as an excuse to discriminate on the basis of race or natural origin. That is wrong, and that is already illegal under federal law. The issue raised by the Democrats is one that is addressed by enforcement of our existing laws. I would urge my colleagues to oppose this bill, and I yield back.
Without objection, all of our other opening statements will be included in the record. Without objection, a statement in support of the Crown Act from the bill's sponsors, Representative Bonnie Watson-Coleman, Representative Barbara Lee, Representative Gwen Moore, Representative Ayanna Pressley, Representative Ilhan Omar, will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 2116, offered by Mr. Nadler of New York. Strike all that follows after the enacting clause and insert the following. Section 1, short title.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will now recognize myself to explain the amendment. The amendment in the nature of a substitute simply changes all but one of the references to the United States in the findings section to U.S. Otherwise, it makes no substantive changes to the bill, and I urge all members to support the amendment. Are there any amendments to the amendment in the nature of a substitute? For what purpose does Mr. Cohen seek recognition?
Strike the last word.
The gentleman is recognized.
Thank you, Madam Chair. I appreciate the chairman having brought this bill up for markup. I'm proud to be a co-sponsor, and last year Representative Cedric Richmond and I were the two prime sponsors of the legislation in the last session. I introduced similar measures concerning hair braiding in 1995 when I served as a state senator in Tennessee.
and there was discriminations against hair braiders in Tennessee, and that needed to stop. Everyone in this country deserves the opportunity to go to work and without their employer trying to change who and what they look like. It should never be the case that people are sent home from work because of their natural hair. Too often, hairstyle and other grooming standards are used as a proxy for racial discrimination. It's just that simple. And if not racial discrimination per se, it's in the fact of ignorance of the people who try to enforce some style decision, not understanding the natural hair and the choice of the parties that exhibit that particular hairstyle. Whether overtly or not, that happens and it must be addressed. Some employers may discriminate in this manner on purpose. Others may develop their dress codes or hairstyle rules without stopping to think about the implications, being ignorant but without a nefarious intent. Hope this bill helps the second group of employers think through the implications of their actions and how they might affect different people. The fact that employers might not even think about this when creating their own policies highlights our cultural blind spots, the types of everyday encounters that people of color have with racism in our society. This bill doesn't just apply to employment, its protections also apply to grooming requirements for school sports, for example. We already see essential changes in this respect. Many states have adopted state crown acts. The military recently updated its grooming standards to better respect the differences in natural hair. This bill will extend these protections nationwide. This is important to reckon with, and this bill does that by prohibiting discrimination of this kind. I appreciate the opportunity to speak, and I urge all members of the committee to vote in support of this bill, and I yield back the balance of my time.
For what purpose does Ms. Ross seek recognition?
Ma'am, if I can, I'd like to.
I apologize. Yes.
I forgot to introduce without objection, a statement from Walmart in support of the bill.
Without objection.
Thank you.
It is so ordered. For what purpose does Ms. Ross from North Carolina seek recognition?
Madam Chair, I move to strike the last word.
The gentlelady is recognized.
Thank you, Madam Chair. Earlier this year in my state of North Carolina, a Black student athlete was singled out by an umpire who told her that she needed to either take the beads out of her hair or leave a softball game. This young woman ended up having to cut her braids simply to play softball. Another Black 6-year-old girl was not allowed to play a recreational soccer game because of her hair clips. This is plain wrong. No one should have to experience this level of humiliation. Targeting hairstyles that discriminate against Black and brown students is simply a relic of this country's history of slavery. We even see this at the highest levels of competition, with the Olympic Committee's decision to ban the soul cap, directly discriminating against Black swimmers for whom this cap is designed. The Crown Act would prevent such actions by prohibiting discrimination based on hairstyle or texture and working to prevent the bias and discrimination faced by Black women, men, and other minority communities. The deeply rooted system of hair-based discrimination presents considerable obstacles to education, participation in sports, employment, and other aspects of life. I'm pleased that the city of Raleigh, North Carolina, recently passed an ordinance forbidding discrimination based on hairstyle and texture. It's important that we work to expand these protections federally in an effort to dismantle the systemic bias that has continuously deprived minority communities of important opportunities. I urge my colleagues to support the bill, and I yield back.
The gentlelady yields back. For what purpose does the gentlewoman from Georgia, Ms. McBath, seek recognition?
Thank you, Madam Chair. I move to strike the last word.
The gentlelady is recognized.
Thank you. I'd like to thank Congresswoman Bonnie Watson Coleman and Senator Cory Booker for introducing this legislation, which I proudly co-sponsored last Congress and proudly co-sponsoring in this Congress. And I also want to thank the many people that are working across the country to enact this legislation at the state and the local levels. You know, every day we encourage our children to be their authentic selves. We encourage our sons and our daughters to be expressive. We tell nieces and we tell nephews to be bold, be brave. We help the children in our lives, whether they are family, friends, or neighbors, to see themselves in the stories that we tell, no matter what they look like. We expect our classrooms to embrace the differences and to help students appreciate the uniqueness in each of us. It is time that our laws do the same. The Crown Act extends our anti-discrimination laws so that they better embody respect, free expression, and appreciation of difference, including natural hair and culturally meaningful hairstyles. Our laws must reflect the values that we give our children and protect them from discrimination. With the passage of the Crown Act, we can protect everyone's right to be themselves at school or at job interviews, and also in public. We can tell the children in our lives, be your truest self. And at this time, we can know that our laws actually reflect that same sentiment as well. So I'm pleased once again to stand with my colleagues in supporting this bipartisan legislation. And I yield back the balance of my time.
The gentlewoman yields back. For what purpose does the gentlewoman from Texas, Ms. Garcia, seek recognition?
Madam Chair, move to strike the last word.
The gentlewoman is recognized.
Well, I first want to thank the chairman for bringing this forward. I know we considered it last Congress. I probably voted for it last time, and it will plan to do the same. I also want to thank all the sponsors and all the original co-sponsors for, putting this back on the table. Today, we're taking bold steps to meet the needs of the American people by, among other things, prohibit discrimination based on a person's hair texture or hairstyle if that style or texture is commonly associated with a particular race or national origin. Particular race or national origin. I'm a proud co-sponsor of the Crown Act because individuals like Andrew Johnson, a student from New Jersey who was forced to cut his dreadlocks to avoid forfeiting a wrestling match, or DeAndre Arnold, a senior at Barber Hills High School outside of Houston, who last year was told by school administrators to cut his hair to attend prom or his spring graduation ceremony would continue to be discriminated due to his natural hair. Unfortunately, too many people like Andrew and DeAndre are adversely impacted by losing their jobs or opportunities because of who they are. But the reality is that America cannot live up to its true potential if we are to erect barriers among us rather than embracing the full authenticity of who we are. Madam Chair, this bill needs to pass, and I also want to include for the record, I ask for unanimous consent to submit a document, an article titled, Texas Lawmakers Consider a Bill That Would Prevent Schools and Workplaces from Discriminatory Bans on Dreadlocks and Other Hairstyles. This is still a problem. I listened to the ranking member, and sure enough, there are a lot of laws, but like a lot of laws, a lot of people don't follow them. I was a hearing examiner with the Equal Employment Opportunity Commission. I've heard a lot of discrimination cases. Even though there's a lot of laws saying they can't do it, there's a lot of EOC guidelines that say people can't do things, they continue to do it. That's why the time is now. We must act and pass the Crown Act. With that, I yield back.
It is so ordered and without objection. The gentlelady yields back. For what purpose does the gentlewoman from Texas seek recognition? The gentlelady, Ms. Jackson Lee from Texas, is recognized.
Let me as well acknowledge H.R. 2116, the Creating a Respectful and Open World for Natural Hair Act of 2021, and thank my colleague, Congressman Cohen, for leading on the first introduction of this legislation, along with Cedric Richmond, and acknowledge as well my friend and colleague, Bonnie Watson-Coleman, and any number of colleagues who have co-sponsors. I'm very proud to be a co-sponsor of this legislation. I'm glad that the chairman initiated the discussion by saying that we had hoped that the general civil rights laws would have protected so many that have been diminished and defeated by insulting their integrity, their dignity, and really their humanity, by causing them to feel ashamed. Ashamed, first of the color of your skin or the language that you speak, and now your hair. Can anyone understand that shame and to think that civil rights laws would not be protective of those individuals? And the greatest insult of all of that is that these are in fact children. And so I just simply want to share a little bit more detail about DeAndre Arnold. But for the past few days, Arnold, a senior at Barbers High School in Mount Bellevue, pretty isolated location, if I might say, hasn't been in school, not because he's a dropout, but because of his dreadlocks that he'd been growing for years, his sense of pride, his connection to a heritage that many may not understand. Why should he be discriminated against? He might not, and he did not, get to attend his senior prom, and with graduation coming up in a few days, he might not, and he did not, even get to walk across the stage with his friends. His case became a case celeb. Stars from all over the nation supported him. He was victorious in a lawsuit, but I can assure you, he is brandished, he is hurt for life. He is tainted in terms of his own self-worth for life. So many rallied around him so that he would not live with that stain. What about the black girl sent home from school over hair extensions in a Roman Catholic school near New Orleans, asked to leave the class on Monday because administrators said her braided extensions violated rules? Or what about a young man who was wrestling, who we've heard about, stood on the side of the wrestling court and was so humiliated that his dreadlocks were sheared off? Read the story of Samson and understand how destructive that can be, the biblical story. So this issue is intimately important to me because just last year, I spoke to you about Mr. Arnold. However, his school routinely inspected his hair for potential violating and ultimately suspended him. I'm thankful that he made a recovery, but I said, tainted for life. In 2017, a Banana Republic employee was told by a manager that she was violating the company's dress code. And teenagers trying to get jobs in Six Flags in Texas were told they couldn't be hired. They couldn't get gainfully employed. They couldn't do what was right because of their hair. 2018, Andrew Johnson, again, as I said, was engaged with this whole issue of how your hair looked. If we have to pass legislation that addresses the many different hairstyles that I happen to have had, not trying to show pictures of Sheila Jackson Lee, but I am showing the fact that black women have so many different hairstyles. About the one that I had when I had breast cancer and had no hair, and it was growing back. Different hairstyles should not be the definition of your dignity. And so, personally, I say, give us the Crown Act, not because we want to be different, it's because we want to be the same. We want to be given respect for who we are, and as Dr. King often said, the content of our character, not abusing little children, 11-year-old, a wrestler, a high school graduate, how excited his family was, and yet he was denied, not because he misbehaved, did not meet the credentials of graduating, but simply because of his hair. Mr. Chairman, this is a needed bill. I ask my colleagues to enthusiastically support it. I yield back.
The gentlelady yields back. For what purpose does the gentleman from Utah seek recognition?
That's the strike last word.
Gentleman is recognized.
I grew up in Deep South in the 1960s. My first encounter with white Americans wasn't until I was 16 years old. At that time, interracial dating and marriage was taboo, actually unheard of in my community. 50 years later, I have 6 children and a family that represents the color of the rainbow: white, black, Hispanic, American Indian, and a little tab of Trinidadian. And by the way, we call ourselves family. This bill targets African Americans or people of African descent. It demands that I give each of my grandkids different advice based on which of my children are their parents. If not Black, when playing sports at a public school or applying for a federal job, I'll have to tell them to respect the expectations and rules of the coach or the employee. My message is their job to give you, is your job to earn. How you dress, how neat you show up, shows respect for the employer or the coach and the culture they've worked hard to maintain. Based on this bill, I'll tell my Black grandkids something different. It's their job to give you, but because of your skin color and the critical race theory you're being taught in public schools, instead of how to read and write, you don't have to do anything extra to impress your boss, your teachers, or your coach. Because you're Black, you can totally disrespect their professional or academic culture to show off your individuality. If you're playing sports at a public school, you can totally disregard the rules of the coach put in place to ensure your safety in order to wear whatever the hairstyle or color that your culture demands for that day. Since you're Black and entitled to express yourself, if your boss or school takes issue with your hair, they must be racist. I think this bill is demeaning and racist. It's demeaning because of this bill, Democrats are teaching our Black children a lie regarding success. They're teaching our children that because you're Black, you can demand something of someone else, disrespect them, and still believe it's going to end well. It's racist because it's only our Black youth that we're telling this to. The message, because you're Black, you should not be expected to play by the same rules and keep the same high standards as everyone else.
Would my good friend yield?
Once I get done in a few minutes. What comes next in the real world with this attitude? When our kids are not hired or fired because of insolence or disrespect, it always is the other guy. Their potential boss must be a racist. It's time we start teaching our Black youth it's time we stop telling our teachers, our Black youth, how to fail and feeling no shame as we do so. I prefer to teach our youth what my parents taught me and what I've taught my children. It works for everyone, regardless of race, creed, or color. Love God, country, family, respect, that word again, respect women in authority. And for the sake of this hearing, let's teach our children, all of them, to respect the business culture of the person who is willing to trust them with a job until they are willing to start their own business. And at that time, they can go for it. Dress any way they want, wear any crown you like. It's your business. I yield to the lady from Texas.
Mr. Congressman, let me just say that I am always impressed when I hear of the United Nations, of your family. So many Black families are in your same situation of having a multicultural, wonderfully inspirational family. I think you've missed the whole issue of this legislation. Frankly, it is a civil rights legislation. It does not speak to anyone's disobeying of any rules relevant to one's learning, playing, sitting in a classroom. None of these children misbehaved. Their only fault was that their heritage, of which they connected to, was their hairstyle. The only fault of those who are applying for jobs in Texas Six Flags, not that they were disorderly, unclean, but because of their hairstyles, which was reflective of many in America.
Can I reclaim my time?
And the same with my hairstyle.
I have to reclaim my time.
Please don't blame them. I yield back.
The message, and we have to understand this, there are people who work hard to build businesses. They build business with a vision of what their business should look like that reflects them. If we're going to ask for someone to give us a position in their business, they set the parameters. We have a choice. Do that or go somewhere else. That's the beauty of our great country.
Do we have a choice of being discriminated against at golf clubs?
Can I just finish, please?
Gentlemen,
the choice we have, first of all, is allow business owners to create the environment they want to. Playing with the New York Jets and Raiders, I could not show with a different color because I felt different. I yield back my time. Thank you.
Gentleman yields back. For what purpose does Ms. Bass seek recognition?
Strike the last word.
Gentlelady is recognized.
Accommodations.
Let me just say that I also wish that what the ranking member's comments and my colleague from Utah said were actually the case. And so some of the logic of my colleague that just spoke is that I guess if a business owner just decided they only wanted to hire people of one ethnicity, that would be okay as well. When I think of the children who actually had their hair cut by school administrators or who were prohibited from being on teams because of the way they wore their hair, that has nothing to do with a job. I don't believe that a student has a choice as to whether or not they are going to attend a class. And I think it is egregious that a young person would be prohibited from being on a sports team because of their hairstyle, or that a teacher would actually use scissors to cut their hair without the parental permission. I remember a few years ago, the members of the Congressional Black Caucus were approached by active military service men and women who told us, and especially the women, told us that the military had submitted guidelines for the hairstyles that essentially only Black women were required to adhere to, because the hairstyles that were on the form did not actually apply to women unless you wore your hair natural and you were African American. We had to bring the military to task. This was just 2 or 3 years ago, and I'm sure Representative Jackson Lee remembers this. I think my other colleagues, it was before their time in Congress. But we had, the Congressional Black Caucus had to take the military to task and get them to rescind that because it was obvious and open discrimination. Let me submit for the record this letter in support of H.R. 2112. I would like to ask unanimous consent to submit this letter in support of H.R. 2116. Thank you.
Without objection.
And just reading a small part of it, there is a longstanding history and problematic practice of racial discrimination based on hair in the US. There have been countless cases where Black people have been discriminated against for wearing their natural hair and our protective styles, including but not limited to braids, twists, etc. This prevalent form of racial discrimination includes being fired, passed over for promotion, and even having employment office rescinded. It impacts the upward mobility of individuals and families, and it has been the reason far too many children have missed school and have had negative educational experiences. Unfortunately, it warrants a legislative fix. And with that, I yield the balance of my time. Thank you.
The gentlelady yields back. For what purpose does Mr. Bishop seek recognition? Mr. Roy, I'm sorry.
Okay. I'll take it. Thank you, Mr. Chairman. I yield to the gentleman from Utah.
For what purpose does Mr. Bishop seek recognition?
To strike the last word.
Gentleman's recognized.
And I yield to Mr. Owens.
I just want to address one of the issues about an adult cutting a child's hair or doing anything to that child without parental consent is absolutely wrong and should be accounted for it. And that's the same with abortion, by the way. The same with anything that people do to other people's kids without their consent. The choice is if you have an environment, and I don't care if it's black, white, it doesn't matter what the environment is for a business owner. Have an environment that they set the parameters for everyone, not just blacks and whites, but everyone, that everyone on that team, everyone in that environment, in a culture should feel the same way. I'm gonna tell you something. This environment we have here, this culture and this Congress, this committee that we have, there's a culture. We expect, our constituents expect us to dress a certain way, to represent them. We come in here doing something totally different. Spiked hair, green, yellow, blue hair. It doesn't matter, we do our own thing. They have the right to fire us. And we don't have the right to call them racist because we're not representing them anymore. Every business owner works hard to create a culture that works for them, that's successful for them, and we should teach our kids to respect that. I'm just gonna say this real quickly because it kind of highlights a little bit of what I said earlier too. Let me tell you what my parents' generation, that great, remarkable generation taught us. to love God, country, family, respect women, and authority. Respect was big time. We start respecting each other, respect our business owners, respect those who go out there and take a risk. And if we want to be part of that culture, then become part of that culture, assimilate, do what you have to do, or find something else. Or here's a better thing, build your own business and then go for it. Whatever you want to do, it's all yours. But if it's not succeeding in your own business, don't expect another business owner to succeed by you choosing to change their culture around. I yield back. Back to Ms. Bishop.
And I yield back to the chair.
The gentleman yields back. For what purpose does Ms. Scanlon seek recognition?
I move to strike the last word.
Gentlelady is recognized.
Thank you. You know, earlier this month, I had the opportunity to meet with student representatives in my district from the Jack and Jill organization, and they shared with me how important the passage of the Crown Act is to them. These students, young women of color, spoke of the unfair bias that they've experienced just for wearing their hair naturally. Race-based discrimination has been happening unchecked for far too long. We need this legislation, the Crown Act, to make it clear that discrimination based on natural hair is a form of race discrimination. My young constituents deserve to have every opportunity open to them and shouldn't be denied educational and professional development for being their authentic selves because of their natural hair. I was proud to tell the students that I was already a co-sponsor of the Crown Act. I strongly support the Crown Act, and I look forward to passing it out of committee today. I yield back.
The gentlelady yields back. For what purpose does Mr. Gomer seek recognition?
Strike the last word.
Gentleman is recognized.
And I appreciate that. And I expected to vote for the Crown Act, but I've heard some things that concern me. And just so you know, a lot of you think I'm warped. Must have been something in my past. When I was in high school, my principal told me that I had the ugliest haircut, and I did have hair, but I had the ugliest haircut he had ever seen. And he was brand new, and another teacher said, Louis is one of our top students. He's president of his class. He's this, that, and the other. And he said, well, he will only be if he gets a different haircut. So I had to get a different haircut. And we had a lot of headbutting between me and the principal, and especially when I was student body president. So I had to go over his head to the superintendent a number of times. And I think he always resented me for having such an ugly haircut. But nonetheless, I've heard a couple of things that concern me about the bill. For one thing, now I was thinking this was, and I'm very serious about this, I was thinking this was only about hair, but then I heard examples about athletic events or swimming, and somebody being told you can't have that hair clip, you can't have those beads, and I don't know if there was anything sharp on the beads, but I do know I've competed in swimming events and been a lifeguard, and we did not allow anything that had anything that might poke another person, or depending on what type of swimming pool.
The gentleman yield.
Poke the liner. I will in just a moment, but I was going to yield to Ms. Bass. I'm curious, and I have great respect for Ms. Bass, and I've been able to talk to her about a number of things over the years and find her to be very candid, very honorable and honest person. But do you anticipate this bill preventing people from saying at athletic events or in sports, you can't wear this because it has a sharp point or it has sharp edges and it might hurt other competitors? Will this act do that? And I would yield to my friend, Ms. Bass. I see she's not on right now. But if somebody else can answer that, I am very curious. if it's expected that this is going to allow people to have
Yes, would you yield to
foreign
me?
objects in their hairs. Sure, absolutely.
Yeah, this has nothing to do with objects in the hair. This is purely a question of hairstyle, period. This has nothing to do with what you put in your hair or how you comb your hair or whether you use whatever products or hearing aids or whatever. This is purely a question of hairstyle.
Will the gentleman yield to me, Mr. Gomer?
Yes, I will also.
Pursuing
Hello,
that,
was somebody talking to me?
Well, yeah, let me yield to Mr.
Oops.
Bishop, and then I'd like to
Hold on a
yield.
second, I'm sorry.
Yeah.
I can't hear you. What were you saying, Mr. Gomer?
Let me yield to Mr. Bishop, and then I would like to get your input after that.
and I'll be quick, Mr. Chairman, I was just going to suggest that the example given by Ms. Ross earlier in her testimony about ribbon or beads in the hair of someone at a soccer game, and another, my concern would be if somebody's hair were being swung around or something, could it hit somebody in the eye? Was there a safety concern? I think that's what Mr. Gomer's question gets at. Now, yield back to Mr. Gomer.
Yeah, well, I wouldn't be that concerned about beads unless there were sharp edges in a competitive sport. But with regard to the example of a hair clip in the hair, back when I had some, when I was young, it was not unusual to have rules in competitive events. And I would expect that. I wrestled in college, and you couldn't have anything anywhere, but especially in your hair. So I want to yield to Ms. Bass for the question, do you anticipate this bill would prevent people from saying you can't have sharp objects in your hair when you're competing?
Well, no, I can't imagine sharp objects flying around or anything. You know, if you had beads or anything like that, it's pretty common to pull your hair back in a ponytail. As a matter of fact, if you watch NFL games anytime, you will see men with braids that are pulled back into ponytails. So natural hairstyles are actually able to be controlled. So they actually are not dangerous, even though sometimes at airports, especially African-American women, get their hair searched. I've never heard of anybody having their hair searched except for Black women, because it has been this mystery over many years that we have the ability to hide things in our hair. And so again, if this were the case with all women, then it wouldn't be an issue, but it is not.
Well,
The gentleman's time has
appreciate that,
expired.
and reclaim.
The gentleman's time has expired.
Well, the example of the hair clip, you ought to be able to tell people you can have a sharp hair clip.
Gentleman's time
We'll
has
talk about it
expired.
later.
For what purpose does Mr. Johnson seek recognition? Mr. Johnson of Georgia.
Mr. Johnson, you're muted. Is he frozen?
Mr. Johnson, you're muted and frozen.
He's froze. Nope.
Does Mr. Roy seek recognition?
Mr. Chairman, yeah, sorry.
Wait, I think Mr. Johnson of Georgia, you're recognized, but you're muted.
He's not hearing.
Mr. Johnson?
Mr. Johnson?
He's not
Mr.
hearing.
Johnson of Georgia. You're muted.
That everyone has.
Mr. Chairman, thank you for recognizing me. I move to strike the last word.
Gentleman is recognized.
I'll yield to Ms. Jackson Lee as much time as she may consume.
I thank the gentleman. I hope Mr. Gomer, my friend from Texas, who I've worked with on a number of issues, will still vote for the legislation, because I think it is the intent on which he wanted to vote for it. Let me reinforce, as one who has braids, that I hide nothing in the hair. I have nothing that can be considered an attack weapon, simply braids. And I think I want to emphasize the 11-year-old girl who, the video went viral. She was a 6th grader, name was Faith, and she was crying as she packed up her belongings and left her school, a sixth grader. And she had nothing more than some braids like mine. Mine are wrapped up, hers were hanging down. The only thing this legislation does is to counter my good friend from Utah's acceptance. We can't accept, and we did not accept with the 1964 Civil Rights Act, that if you were a business, and we wish businesses well, my husband would drive across country in a Ford with his family of 6, and they had to make sure that they got somewhere safe before dark. They had to go to the back of the restaurant, and they had to find a place to rest themselves and do other normal things. That was pre-1964, when businesses could tell you to take a hike. If you were Black, you could not go into or be accommodated by hotels and restaurants. That is not what we're here for. So it's not about a business. It is about discrimination on the basis of race. That's what we do in this committee. Basis of being a Native American, basis of being a Hispanic, basis of being disabled, basis of being an elderly person. And so this is this is discrimination on the basis of your hairstyle. And I might imagine that if there was a hairstyle in the old days of the hippies, they would be covered because it was a hairstyle. And so do you want to see children crying who are 11-year-olds? Or what about the little first grader in Florida, excited about school, and the little first grader was turned away? And then the wrestling with nothing hidden in the gentleman's hair was not, in fact, discriminatory on the basis of he has something in his hair. It was the basis that he had dreadlocks, which, as my colleague has said, that is the most flexible hairstyle. He could have been asked to wrap it up. He could have been asked to put it in a bun. It would have gone in a bun. It would have been off his neck. You have to be culturally sensitive to be able to ask, okay, why don't we put it in a bun, sir? But he had to stand on the sidelines while all the world to watch him be humiliated, not only as a child, but as a young Black man, for what he could have done if there was cultural sensitivity. So the discrimination issue tracks the 1964 Civil Rights Act, where you could not be accommodated, and the 1965 Voting Rights Act, where you couldn't vote. So my friends, it is a simple protection. It is not to indict anyone. It's not to underestimate anyone or undermine anyone. It is to suggest that you cannot do this to children or adults as relates to simply their hairstyle, culturally connected or because they like long hair. And when I say that, that would be groups particularly that might not be, happen to be African American. So I'm stunned that we don't have all the Republicans voting on this, because it's about discrimination because of hair. Mr. Goldman, I'm not sure whether your ugly haircut was because it was long or whether or not it just didn't get the clippers right. But I would believe that your ugly haircut would have been appropriate, and maybe if it was long, you could have wrapped it up. But we're talking about people's dignity and their rights as an American. That's what the Crown Act, and that's why it is so important, and that's why Chairman Cohen, it is relevant to the Constitution Committee. It's about your constitutional
Time of the
right.
gentlelady.
I yield back. Thank you, Mr. Johnson.
The time is expired. For what purpose does Mr. Gates seek recognition?
I move to strike the last word.
The gentleman is recognized.
Thank you, Mr. Chairman. And Mr. Jordan made a point earlier that I don't think we've gotten an adequate response to. What in our current Constitution and our current laws are insufficient to deal with these instances of racial discrimination? There's not a single member I'm aware of on the committee who isn't deeply torn and impacted by these stories of people being treated poorly as a consequence of race or ethnicity.
Does the gentleman yield?
I would, yeah.
Well, as I said in my opening statement, the The problem is that the Civil Rights Act of 1964 does provide this, for this, but the Supreme Court held some of those provisions unconstitutional, and we have to, on a state level, and we have
Yeah,
to...
reclaiming my time, Mr. Chairman, I don't think that the Civil Rights Act is more applicable than the Equal Protection Clause. To me, the Equal Protection Clause creates a framework by which if someone is part of a suspect class, they can seek redress.
With the gentleman,
I would.
well, unfortunately, there remains a split among the courts on this question. For instance, the 11th Circuit has rejected the view of the Equal Opportunity Employment Commission, the Title VII of the Civil Rights Act of 1964, which prohibits employment discrimination, would prohibit discrimination based on hairstyles reflecting natural hair texture. By contrast, the Seventh Circuit has adopted certain views, so we have to straighten it out.
Yeah, it strikes me that when there's a deviation by lower courts on those questions, perhaps allowing the judicial process to resolve itself with decisions of higher courts would be better apt than embracing what seems to be grievance culture. And, the Equal Protection Clause applies to all Americans, and it doesn't create, I think, that sense of grievance that my colleague from Utah has reflected on rather eloquently, and I would yield the remainder of my time to my colleague from Utah.
Thank you. The bill targets, and this is quote, African Americans or people with African descent. This bill forces me to have a totally different conversation with each of my 15 grandkids. Based on who their parents are, a few can be individuals and do their own thing regardless of what the job says. The other ones have to apply to the same rules. When I have to talk to my kids differently based on their color or their parents' color, that's discrimination. If you're going to make this happen, just make for everyone. Don't make for African Americans. Don't point to our kids and tell them you have separate standards, you have separate grievances, and you can do what others can't do because of your skin color. Make it equal to everyone. And I think we're all on the same page at that point, and then I'll be all on board. But I'm tired of my race being targeted for special grievances, for special options, in which they will pay the price. Because at the end of the day, folks love people who respect their business, their culture, whatever their environment might be, and those are the ones that will always continue to not only get the jobs, but continue to rise.
Would the gentleman yield?
Actually, I have the time.
I will go back to my time.
Would the gentleman yield?
In a moment, I also have to look at the remedies in this bill, and do we really think that the best use of our federal courts is to resolve hair issues? It's just kind of a sad commentary that it's gotten to this place. I wish these circumstances that my Democrat colleagues reflected on had never happened, but I would hope there'd be an easier way to resolve it than federal litigation over hair, and I would yield to the chairman.
That's exactly the point. To the extent that there's ambiguity in the courts, by passing this bill into law, we will ensure that courts properly view discrimination on the basis of hair texture or hairstyles commonly associated with a particular race or national origin as illegal forms of race or national origin discrimination. We don't have to wait for the courts. Discrimination is discrimination.
Well, I think the chairman speaks to the impact of the legislation in a world in which lower courts are divided, but I would suggest that anytime someone is being mistreated as a consequence of their race or national origin, the Equal Protection Clause already prohibits that activity.
Yeah,
so
but the courts have split on that question right here.
Right, but that's what always happens in the litigation process. You have divergent opinions among courts, and then those questions move to higher courts for resolution. And I think that a higher court could resolve this question precisely how my colleagues.
We don't have to wait for the higher court. We have the statutory ability to deal with it
Mr.
now.
Chairman, instead of waiting, we're engaging in the very practice that Mr. Owens cautions us against, which is like crafting this special legislation regarding a particular community when it may not be necessary and it may clog the courts.
This doesn't regard a particular community. It forbids all discrimination on the basis of hair texture.
I read the legislation as having a particular application to a particular race. The race and ethnicity tied to the hair is what I think would avail the
time of the gentleman has expired. For what purpose does Mr. Ben seek recognition? Gentleman is recognized. Your mic.
Thank you, Mr. Chair. This is a question that comes up on page 9, lines 9 through 25. The issue is whether or not the prohibition against discrimination would moot an employer's efforts to impose upon the workforce obligations to have shorter hair for reasons pertaining to safety. So, and there could be other reasons, but I'm going to use safety here. And the language in question is found down on line 14 and 15, where it says hire or to discharge any individual or otherwise to discriminate against an individual based upon hair or hair texture or hairstyle. So the hypothetical I would place before the committee is if an employer says, hey, we have a production line and we're worried about someone's braids being caught up in it or dreadlocks, we are therefore going to say no to everyone. It doesn't matter what race you might be, but this is a matter of safety. And I just wanted on the record that employers would not be prohibited from such.
Would the gentleman yield?
Yes, I will, please.
The employers would not be prohibited. This says nothing, as the employers would not be prohibited as long as they do it in a racially neutral manner, as long as they apply it to everyone. Whatever rules they may have, as long as they apply it to everyone, that's okay.
So, Mr. Chair, if I may, I wonder, that seems to fly right in the face of the nature of this bill, which is calling out an individual group and saying you will not. And I'm just worried that someone might come in, that someone of the group protected by this bill or intended to be protected by this bill comes into the employer and says, I'm sorry, Mr. or Ms. Employer, but it says here you can't discriminate against me. And I just wanted clear as a bell on this record that they can, so long as this prohibition applies across the board. But
That's
they will
exactly
say,
right.
won't they say, Mr. Chair?
That's
But no one else in this work group is black,
The
therefore.
gentleman yield that he is
Yes, I will. Yeah.
He's exactly right. As long as it's applied across the board,
No.
it's okay.
Mr. Chair, forgive me, but it seems to me that this bill says that if you are black, and I'm not sure exactly which race this applies to, but whatever race it does, you would have an argument that you are being discriminated against because you are different than everybody else is in that workforce.
There is no language in the bill about being black. This applies to everyone. Now, it is true that in the past there has been discrimination, and there still is discrimination, usually against black people on the basis of hairstyle, and the point of the bill is to say you can't discriminate against blacks or anybody else on the basis of hairstyle.
So, Mr. Chair, just for purposes of clarity of the record, what I am hearing is that an employer can say to everyone there, even though it only applies to those who happen to have dreadlocks, even though it only applies to that group, the employer's only talking to everybody, but it only applies to one sector of their employment population. They are not discriminatory. That's what you're saying.
No, it applies to everybody. Now, it is true that it's true that the hairstyle, if that hairstyle, no individual in the United States shall be excluded from participating or from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance based on the individual's hair texture or hairstyle. If that hair texture or that hairstyle is commonly associated with a particular race or national origin, period.
Mr. Chair, I just want to hear again that an employer can issue a regulation across the board, but as a practical matter, it only applies to those who happen to be of the race that this bill is intended to protect. Even just by the very nature of the situation.
As long as it's racially neutral, yes.
So yes, the employer can impose a regulatory requirement that you cannot have dreadlocks because they might get caught in some equipment, even though it only applies to one narrow group of employees.
Your time's about out, Cliff.
I yield back.
The gentleman yields back. Votes have been called on the floor. We'd like to move to final passage on the bill now.
No. Wait a minute. He's seeking recognition. He's
Mr. Biggs is recognized. And then we'd like to go to final passage.
Move to strike the last word.
The gentleman is recognized.
Thank you, Mr. Chairman. I'll yield to the gentleman from Utah, to the gentleman from North Carolina, Mr. Bishop.
Look, I think that, the thing about Mr. Bentz is that he frequently does what is very serviceable to the committee, and that is point us to the language of the bill that is proposed. And Mr. Bentz is exactly right. The relevant language is, and I'm going to use ellipses and read it so that it can be read understandably, but it says that it shall be an unlawful employment practice for an employer to discriminate against an individual based on the individual's hair texture or hairstyle if that hair texture or that hairstyle is commonly associated with a particular race or national origin. Now, let me use an example, and I'm not sure this example is completely apt, but let's assume dreadlocks. That was mentioned earlier today. If you assume that dreadlocks are associated with a race or a national origin, I think that may even be true. I don't know, Jamaicans or something that wear dreadlocks long, and they present a source of danger. Well, this statutory language requires the employer not to discriminate against that hairstyle. The employer cannot require that employee to cut that hair. Now, the interpretation that the chairman proposed, that it doesn't do anything unless you're treating somebody differently that has dreadlocks, that's not true. As long as the dreadlocks can be shown to have an association with a race or a national ethnicity, then this language prohibits the employer from imposing a term or condition of employment in connection with that hairstyle. That's what you've done. I think it also has an object lesson, which is when you are governed not by common sense, but by grievance politics at every turn, you're going to inevitably create disastrous consequences. You're going to expose people to danger because of the careless, reckless drafting of this language in a way that would prohibit an employer from keeping an employee safe. And with that, I yield back to the gentleman from Arizona.
Mr. Chairman, I yield back to the chair.
Gentleman yields back. The question occurs on the amendment in nature of a substitute. This will be followed immediately by vote on final passage of the bill. All those in favor respond by saying aye. Aye.
Aye.
Opposed, no. In the opinion of the chair, the ayes have it.
Mr. Chairman.
Request the yeas.
Mr. Chairman, I'd like yeas and nays on the amendment.
Reporting quorum being present, the question is on the motion to report the bill.
Mr. Chairman.
Jackson Lee has a UC request.
Mr. Chairman.
3 articles, New York Times, Black girl denied, sent
Mr.
home.
Chairman.
Stop policing people's hair and African-American teens. Yield back.
Gentlelady yields back. A reporting quorum being present, the question is on the motion to report the bill H.R. 2116 is amended favorably to the House. Those
Mr.
in favor
Chairman.
respond by saying aye. Aye. Opposed, no. The ayes have it, and the bill is ordered reported favorably.
These are the 3.
A recorded vote has been requested. The clerk will call the roll.
Mr. Nadler.
Aye.
Mr. Nadler votes aye. Ms. Lofgren.
Aye.
Ms. Lofgren votes aye. Ms. Jackson Lee.
Put these in my chair and submit the statements that you wrote.
Ms. Jackson Lee.
Aye.
Ms. Jackson Lee votes aye. Mr. Cohen. Mr. Cohen votes aye. Mr. Johnson of Georgia. Mr. Deutsch.
Aye.
Mr. Deutsch votes aye. Ms. Bass. Ms. Bass.
Ms. Bass, you're muted. This is final passage.
Aye.
Ms. Bass votes aye. Mr. Jeffries.
Aye.
Mr. Jeffries votes aye. Mr. Cicilline.
Aye.
Mr. Cicilline votes aye. Mr. Swalwell.
Aye.
Mr. Swalwell votes aye. Mr. Liu.
Aye. Thank you.
Mr. Liu votes aye. Mr. Raskin.
Aye. What?
Mr. Raskin votes aye. Ms. Jayapal.
You're saying one.
Aye.
Ms. Jayapal votes aye. Ms. Demmings?
Aye.
Ms. Demmings votes aye. Mr. Correa?
Aye.
Mr. Correa votes aye. Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse?
Aye.
Mr. Neguse votes aye. Ms. McBath?
Aye.
Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Mr. Jones? Ms. Ross?
Ross votes aye.
Ms. Ross votes aye. Ms. Bush?
Mr. Chairman, how am I recorded?
Mr. Jones, you are not recorded.
Aye.
Mr. Jones votes aye. Mr.
Madam Clerk, how am I recorded?
Mr. Johnson of Georgia, you are not recorded.
I vote aye.
Mr. Johnson of Georgia votes aye. Mr. Jordan? Mr. Jordan votes no. Mr. Shabbat? Mr. Gomert?
No.
Mr. Shabbat votes no. Mr. Gomert? Mr. Isa?
No.
Mr. Isa votes no. Mr. Buck? Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Stubbe?
No.
Mr. Stubbe votes no. Mr. Tiffany? Mr. Massey?
No.
Mr. Massey votes no. Mr. Roy?
No.
Mr. Roy votes no. Mr. Bishop? Mr. Bishop votes no. Ms. Fishbach? Ms. Fishbach?
No.
Ms. Fishbach votes no. Ms. Sparts?
No.
Ms. Sparts votes no. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Benz? Mr. Benz votes no. Mr. Owens? Mr. Owens votes no.
Are there any other members who wish to be recorded who have not been recorded? Clerk will report.
Mr. Chairman, there are 23 ayes and 15 noes.
The ayes have it, and the bill as amended is ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in nature of a substitute incorporating all adopted amendments. And staff is authorized to make technical and conforming changes. This concludes our business for today. Thanks to our members for attending. Without objection, the markup is adjourned.